It was 1 second early. It was 1 second early, people. Okay, while everyone trickles in, I got a message on Facebook, and it was someone saying, and I've never appreciated this. They said, could you run something of like a banner or a countdown? Because when it's a monetized live stream, there is an ad that runs before you get into the stream. And if you want to support the channel and be, friendly, you don't skip the ad. You end up missing the first 30 seconds or 10 seconds, however long the ad is. I never appreciated that. I never understood why some people had a countdown timer and others have standard intros to live streams. So for whoever sent me that Facebook message, I think you know who you are, and I'll have to go check to thank you after this if I can remember. I'm going to do it next time. I just couldn't do it before this stream, and I had never thought about it. Everyone in the chat telling me to get a haircut? Never. In fact, people, it has gotten long enough that I can wear a beret now, and it kind of looks reasonably hip, reasonably cool. My God, I've gone gray. Oh my goodness. My brother sent me a video. One of my brothers had backed up all of our childhood VHS memories onto digital format, and I got a video of a video that I made in CEGEP. I was taking a film studies class, and we made short films as part of our projects. And I was rewatching some of the stuff that we did when we were 17 years old in CEGEP. To say you'd get canceled for doing things like that these days would be an understatement. It was the funniest thing ever. May never become public ever, but it was hilarious. The short films that we did and the behind the scenes. Just imagine 6 guys with carte blanche to make a film for a teacher with a good sense of humor. It was epic. Now, that is not the intro. While we wait for everyone to slowly get into the stream, I'll read a couple of the chats. Hello from Australia. Weird time. What's the future like in Australia? And actually, what's it like in Australia right now? I did a stream with Oz. Jeez. Avi Yamini. Oz Olyashev. Not Oz. Who am I talking about? Avi Yamini. And he was saying it's as bad as we think it is here, and maybe even worse. The Freedom Fro is indeed it's coming back, and I think I like it. I mean, I really think I like it. It might be at that stage now where it looks a little borderline unemployed eccentric, not genius eccentric. I'm hoping to get to the genius eccentric stage one of these days. Do not get a haircut? All right, I won't anytime soon. Okay, before I get into the intro of the stream, it's going to be a good stream tonight. We're simultaneously streaming on Rumble, as we always do. Rumble merged with Locals, and so there's like some features where you can find vivabarneslaw.locals.com directly through a widget on the Rumble site. That's not the purpose of this intro. Simul streaming on Rumble if people want to watch it there. It's going to be like it'll be my Samson source of strength. I like it. I like to run my hands through my hair. It makes me feel, I don't know, a little more eccentric than normal. Rumble has Rumble rants. YouTube has super chats. YouTube takes 30% of super chats. If you don't like that, I can appreciate it. Rumble takes 20% of super chats or Rumble rants. So you can feel better supporting a creator, yada, yada. If you want to support over on Rumble, I know some people have issue with the fact if you want to comment, you have to open an account and you have to give a cell number or a telephone number. No system is perfect, but I like Rumble. I liked Rumble before the Locals merger. I've liked Rumble since 2014. I like Rumble, and I like the CEO, and I like the company. So that's where I'm focusing my alternative video methods. The Winston look now available at self-respecting barbers. Okay, so that's it. So the super chat disclaimer, I won't get to all of them. If you're going to be miffed if I don't get to them, don't give them. I don't like people feeling miffed, rooked, shilled, whatever. Where can we get your Vlog Dog shirt with Pudge? Check the pinned comment on, I think, the majority of my YouTube videos. The links to various merch are there, and it's not all good. It's not all organized. I have to figure out how to do it one day. But tonight, I am not wearing my merch. I am wearing Style Boys, which was my first night of Hanukkah, Christmas, Kwanzaa present. I got Style Boys. which is Lonely Island merch, and I love this shirt. Anybody who has not seen the movie Pop Star Keep On Keeping On, one of the most underrated comedies of all time, in my humble opinion. Highly inappropriate for kids. Doesn't mean you can't watch it with kids. Just be forewarned, you'll have to cough over a lot of swear words and put your hands up because there's nudity. Sage Up Theater profs are wild. We did some wild stuff that I can no longer talk about too. Those were the times. I tell you what, they were the times. 1998. And people had a sense of humor and people were not out looking to be offended. Have you heard of Kyle Caruth? Yes, I have. We're talking about it tonight. Okay, so Trouble 3 Down Productions. I like the avatar and I like the branding. Have you heard of the Kyle Caruth shooting? If you could, check it out. I also made a video about it. So that is some good paid promotion right there, Trouble 3 Down. It's been the talk of the week. I watched Andrew Branca, The Law of Self-Defense. I watched his breakdown. I watched Andrew, I actually don't know his last name, Legal Mindset. I watched his breakdown. I know what I think about it, but we're going to talk about it tonight. Can you look into the hundreds of athletes? Okay, I'm not. I read it. I've seen it. The question you have to ask yourself is how many spontaneous heart attacks happen in any given year. I don't know the exact number, but I know that it happens. It's not as you need to know the comparison. I don't know the comparison offhand, so I don't hypothesize. Never cut your hair. Long-haired heathens unite. And we got Howie Z says, it isn't that bad. Most lockdowns are over, and we're getting on with life. It was rough, but having total deaths comparable to some places' weekly deaths to COVID is, in my opinion, worth it. No judgment. I might disagree with some of that, but I haven't lived through what you've lived through. So my disagreement would be from a perspective of not having had your life experience. Pudge, proof of life, maybe. Okay, before we get into the rant, people, I'm out of the country. All the coppers have gone to Melbourne. It's life is normal out here. It seems to be how Australians deal with authorities' overreach. Ignore them and carry on. Well, speaking of authoritarian overreach, I've got two things. I'm going to bring up a screen share because this isn't the purpose of the rant, but if you watch this, I don't know who has seen share. Who has seen, let me go like this up here. Who has seen Dr. Fauci? Let me see if I can go to my screen. Listen to this, guys.
Science.
Listen to this.
So if they get up and criticize science, nobody's going to know what they're talking about. But if they get up and really aim their bullets at Tony Fauci, well, people could recognize there's a person there. So it's easy to criticize, but they're really criticizing science.
To criticize Fauci is to criticize science. I mean, and he refers to himself in the third person. He compares himself to the immutable, respectable, praiseworthy field of science. He is that. And if you dare question him or criticize him, you are questioning the gods themselves. I mean, that's what it is in no uncertain terms. That's not the purpose of the rant. The purpose of this intro rant is someone who lacks, you're all seeing my Twitter feed, it's wonderful. Someone who lacks insight and history and knowledge. And when you are a blithering, virtue signaling fool on the social medias, at the very least, understand history, because you might be not making the point that you think you're making. Here we have Justin Trudeau wishing Jewish Canadians happy Hanukkah. And he says, setting aside, I'm not playing the video of him talking because it will probably cause people to shut their computers down. Hanukkah is a time to reflect on life's blessings. And as Canadians, we have so much to be thankful for. To all Jewish Canadians who are celebrating over the next 8 days, Sophie and I wish you a blessed and joyful Hanukkah. And then in his video, he says, celebrate carefully. Now, let me just go ahead and stop sharing and then see how this works. Bring this down. We go down here and bring up StreamYard. Let me see if I haven't lost everybody here. How are we doing? Oh, there's a lot of comments coming in, and I'm going to have to scroll down to the bottom. I missed a ton of chats. Okay. Okay, so we're all with me here. Justin Trudeau is treating Hanukkah the way, who was it that treated Easter like eating chocolate? Like in the mind of the person with no insight into history, no historical knowledge, and no respect of religion, you look at Easter and you say, it's a time to sit down and eat chocolate. And Justin Trudeau is looking around at Hanukkah and saying, It's a time to count your blessings. I mean, he's getting mixed up between Hanukkah and Thanksgiving regardless. And this is not a religious lesson. This is a history lesson that it would have been wise for Justin Trudeau to appreciate what Hanukkah was. And it was the Israelites who were fighting against not the oppression of the Egyptians, because the Egyptians had allowed the Israelites, or the Hebrews of the time, to live freely, to practice religion freely. And it wasn't until Antiochus, and I might get some of the stuff mixed, this is an overview, Antiochus, who came to power and took over. I mean, basically, the Syrians through Antiochus came into power and then came in and oppressed the Israelites. They did not allow them to celebrate their religion. They did not allow them to live a free life. They not only didn't allow them to practice their religions freely, and I'm, not thinking of one Artur Pawlowski under the Trudeau and Jason Kenney Canadian rule. They defiled religion and what it was. They made them pray to other idols, false idols. Much in the way, maybe, arguably, you can draw a similarity between what's going on today and what happened back then. History doesn't repeat, but it tends to rhyme, to quote the great Mark Twain. So you have Justin Trudeau, who is arguably, but not arguably, an individual who, through his government, has tyrannized and oppressed all of Canada, has prevented people from freely celebrating their religion, has locked up those who have tried to freely practice their religion. Artur Pawlowski, I want to forget his name now, the other pastor, Pastor Coates, James Coates, and there was a third one, has led to a Canada in which several dozen churches have been burnt, vandalized, whatever. This is the oppressor of the government saying, go out and celebrate Hanukkah, not actually realizing that what it is celebrating was precisely the revolt and the getting your freedom back from tyrannical regimes that did not allow you to live in peace, celebrate your religion in peace, and be free people. So thank you for the history lesson, Justin Trudeau. You need to know a little bit more before you take to social media just to spout off pleasantries. Virtue signaling nonsense. Okay. That is my intro rant. Now, on the evening of the menu, let me just take one more super chat that I missed here. It was Joe Blow, which was a mathematical equation that I know what it means based on, I was very good at riddles growing up. Let me see if I can't bring it back up. I can bring it back up. I do not endorse certain words, but I don't know. Okay, man, memes have been born out of here. Is Omicron an anagram for moronic? Omicron. It is. It is. Holy crab apples. Well done, sir. Well done, Bison. That's fantastic. I will not say things out loud that can be flagged as inciting or whatever, glamorizing, but found innocent on all charges. Which brings us into one of the other subjects of the evening, the McMichaels, who were not found innocent on all the charges and were found guilty on virtually all of the charges, depending on which one you look at. Anyone who would set himself up as an immutable figure must be removed and dispelled. That is an ego bordering on sociopathy and a God complex. I'm not giving any medical advice. Open parentheses, disclaimer. Nothing in this stream constitutes medical advice, legal advice, or undermining election fortification advice. But I know what a narcissist looks like from a colloquial perspective, if not from a clinical one. Fauci has entered the mode where he thinks he is the literal savior, and his job right now is to save people, but not save people from anything, just to save them from COVID. If they die of overdoses, if they die of undiagnosed cancers, if they die of secondary effects of things, if they die of increased murder rates, doesn't matter. His myopic view of his own godly self is to COVID zero, bring it to COVID zero. And oh my God, listening to Fauci talk, and we don't know if it's too early now to celebrate Thanksgiving in 2021 and Christmas when he's been saying we don't know for 2.5 years or 2 years. Okay, I see Robert in the background. So on the menu for tonight, by the way, everybody, we're going to go through McMichaels. And Bryant. I don't want to call him Roddy because I feel that that's improperly casual. We're going to do the Ahmaud Arbery convictions. We're going to cover the Kyle Carruthers and Chad shooting out of Lubbock, Texas. Project Veritas, Canadian law stuff. Let me see what else I had screenshotted for the menus. Vaccine mandates. Ghislaine Maxwell trial coming up tomorrow. And we're going to do a bit of the history of Ghislaine Maxwell. Robert and I have talked about it in previous streams, but that was so long ago. It might be time to refresh everybody's memory. Kim Potter trial coming up, a bunch of other stuff. So it's going to be one heck of an evening. Before Robert comes in, because I see when I see the red, I can't get all the super chats, but man, I have to be respectful to all of the super chats, but I'll get yelled at by the chat if I let a red one go by and not read it. Please call it the gas variant for one day. I don't know what that means. Messiah complex is the way to describe it. Absolutely. Okay, a couple more just before I bring in a gag order for the Maxwell trial. I'm going to ask Robert. I haven't seen anything confirmed in any article. I've just seen tweets about it with no links to substantiation. Handel Zeus, thank you very much. And Deslov Aktmankari says, you know who hates Trudeau? You know who hates Canadians? Trudeau. You know who hates Trudeau? Canadians. I feel bad. Twitter does bring out the worst in me. Trudeau put out a tweet yesterday and I just wrote, Canadians hate you. And I have not met a Canadian that says they like Trudeau. I see bots on Twitter that say they like Trudeau. And I know people who have voted for Trudeau that still say they hate him. And that is party over country. But a question for another day. All right, peeps, let's bring on the Barnes. Barnes, how goes the battle?
Good.
Do we do it this way so that when I bring up chats, we're going to try it this way, people. If this irritates anyone, maybe we'll switch halfway through. It's wasted space, but I like the way the chats come up a little bit better and don't overpower our face. Plus, you get to see Barnes's beautiful leather couch. Robert, we haven't done it for a while. Let's start with the book recommendation for the week.
Sure. So it's two different books. The book behind me to the right is Bolivar. You can't really quite see it behind the mic, but Bolivar, about Simon Bolivar, after which Bolivia is named, and then in which Venezuela still celebrates, and a lot of people still celebrate throughout Central and Latin America. And then Collapse by Jared Diamond is about how societies, great civilizations collapse, in part because of how they mishandle viruses, as an example. So that might have some apt analogies in the current context.
Robert, so let's, on a professional level, is there anything that you're involved with now that you can give us updates on that we should know about, or nothing worth getting into for the moment?
Any of the vaccine mandate case updates that I'm involved in are going to be at vivabarneslaw.locals.com because of a lot of the subject matter of the conversation of those cases is something that creates censorship risks here on YouTube. So so that's why we're using the locals page to include copies of actual suits, copies of actual briefs, copies of actual court orders. Things of that nature, and I'll continue to update there in terms of the Tyson Foods case, the Children's Health Defense cases, and some other cases that are being filed that I'm either supporting or a part of. That's where we'll have most of the substantive, factual component details. The legal aspects we can discuss here, but the factual details will be there.
Good. And Don Lemon trial coming up, no delays in that?
Don't know yet. So we've requested a jury trial. The defense has requested a judge trial, and we're waiting to hear from the court.
Okay, we'll get into this later with the Ghislaine Maxwell as to why the federal rules do not allow for broadcasting the trial. Just chat, remind me when we get there. Robert, let's start with the obvious one, the one we'll get out of the way right away, which is I've been calling it the Ahmaud Arbery just for ease of reference, but it's actually the McMichaels conviction and Bryant conviction. Everybody watching knows the McMichaels had their trial. Travis McMichaels was convicted on everything malice murder and everything down. His father was not found guilty of malice murder, but found guilty of felony murder all the way down. And Bryant was found not guilty of malice murder, not guilty of felony murder on the gun charge, but felony murder all the way down for false imprisonment, etc. Did you see Andrew Branca's assessment of the trial afterwards? He had a 6-minute video explaining why he thought it went haywire in terms of the charges and the jury explanations. What's your take on the outcome? What's your take on the law that was applied to them?
So, I think that they became politically disfavored individuals because of the media narrative and because of the racial aspect of the case, and somewhat because whether or not citizens should have that power is controversial in parts of the country, including Georgia. So the law itself was actually ultimately repealed after the case that that may have authorized their conduct. In my view, three factors were critical to this case. One is how, what a person thinks, like in this case, what a potential juror or judge thinks about the citizen's arrest statute. So what power do they think do they think the state should have a monopoly on arrest? And if they don't, when do they think the state shouldn't have a monopoly on arrest? The second is, how do people feel about open carrying guns, and how do they feel about confronting people when armed? And then third, how do they feel about home invasion and burglaries in inside neighborhoods? I think, I don't know what questions they asked in jury selection, but my view is those three questions would have shaped whether or not, aside from the pretrial publicity questions, which were just rampant here in terms of pretrial prejudice. I think my own view is that they could not obtain an impartial jury in that community after the degree of prejudicial press coverage, because it wasn't just prejudicial in being hostile towards them. Arbery was always shown in his high school prom photo. McMichaels were always shown in their booking photo. But it was also the racial angle, which was mostly false, at least in terms of what came out at trial. Now, I didn't see the evidence presented at trial. I only saw opening statements, closing arguments, and the judge's charging conference and instructions. So I'm relying upon the prosecution and defense properly summing up the evidence. You never know whether either side missed something, though their adversarial role would suggest that they had no incentive to miss something pertinent or material. But based on that, I didn't hear any evidence of racism at all, at least as was adduced at trial. And I didn't hear, the prosecution wasn't arguing the residential jogger thing by the time of close. So that media narrative was patently false, but it was so prejudicial, I don't think they could get an impartial jury, even with 2 weeks of jury selection in that community. And the convictions on things like malice murder, the conviction on the guy who filmed it, would suggest that within about a day of, maybe a little more of jury taking time, would suggest to me a jury that had prejudged them based on that pretrial publicity. And the judge didn't help by deciding to play Pontius Pilate on the jury instructions. So the big question in the case was the prosecution had my view, a novel theory of the citizen's arrest statute. To give you some idea of how universal the defense's theory of the statute is, you can go to Fine Law and get the legal canon version, the legal treatise version of any issue, and they have how most states interpret their citizen's arrest statute. And what that says is if you have reasonable suspicion that somebody committed a felony, you can arrest them. Not that it be within your immediate knowledge or immediate presence, not that they're escaping immediately after they've committed the crime. So my reading of the Georgia statute, same as Andrew Branca's, same as the defense, was that if you have reasonable suspicion that someone has committed a felony at any time in the past and is currently escaping capture, then you can exercise the citizen's arrest power to detain their liberty, and it's effectively an exception to the false imprisonment.
And let me stop you there just on that one point, because that's one point that requires a question on its own. Within any period of time, we're not talking contemporaneously by your reading, Branca's reading, and I say this without judgment because I know it was ambiguous, but the question is this: like, logically speaking, what indefinite time frame to make a citizen's arrest on someone you suspect of having committed a felony?
Yes, because two things. That's been the sort of common treatise definition. The word escape meant escape from capture, not escape from just committing the felony historically. And the best way to understand this is, particularly in the South, this Georgia statute originated during the Civil War. It was to deal with escaped slaves. So, once you understand that, and that it's been applied in that kind of context, like people who had committed a crime days before, someone had reasonable suspicion and was allowed to exercise force against them weeks before. In the escaped slave context, it's, it can be years before. It's just, hey, here's someone that's so I get why that's politically controversial, but that gives you some idea of the historical antecedent of the statute. And that's why I found the interpretation that the prosecution urged, which was that basically it was an emergency power statute that only allowed you to arrest when you had immediate knowledge of the crime and the person was imminently escaping from that crime.
And sorry, and just precursor to that, and the crime was a felony, not a misdemeanor, correct?
Correct. Here was their interpretation. If it's a misdemeanor, you can arrest them unless they escape. If they escape, then you can't arrest them unless it's become a felony. So
I can understand it in a sense, like, I don't know if shoplifting under $100 is a misdemeanor. And so you make a citizen's arrest, you try to stop them, they run away, and that's where it ends, as opposed to every misdemeanor attempted citizen's arrest escalating because they're going to attempt to flee based on a misdemeanor. To me, the murkier, more nebulous issue was, how does a citizen even know if it's a misdemeanor versus a felony, which gets into the risks of exercising a citizen's arrest. So yeah, you could flee if it's a misdemeanor. If it's a felony, your reading was that no time frame, given the historical context of that law.
In my view, if you have immediate knowledge, you can arrest them whether they try to flee or not. That the escape provision is, if you see and witness the crime, which is what really immediate presence, immediate knowledge means. You could competently testify as a witness of witnessing the crime, whether you witnessed it on a video or witnessed it live. If you witness the crime, you can arrest whether they try to escape or not. And that the second statute is completely independent and separate from the first one. And the second statute is, now, what if you didn't witness the crime? When can you exercise citizen's arrest then? Well, if you have reasonable suspicion that they committed a felony and are escaping, that provides an additional basis. So you have a lower threshold by which you can arrest someone, but a higher culpability before you can arrest them, which makes sense that they would balance those. Under the interpretation urged by the prosecution, the statute makes no sense at all. The statute has a reasonable... So hold on a second. If they're a misdemeanor and they try to flee, then I can't arrest them at all. Encourages flight, which is kind of perverse. But secondly, if they commit a felony and they're escaping, then I immediately witnessed it. I also have to have reasonable suspicion. By definition, I have reasonable suspicion if I witnessed it. So that statute makes no sense under the prosecution's interpretation. So the judge originally is going to, give the prosecution's interpretation on the Friday before the charging conference. Over the weekend, realizes how egregious the legal error would be based on Georgia precedent and all these other treatises out there, of which fine law is just representative and reflective. And all of a sudden flips and decides he's not going to give any instruction. He's just going to read the statute, which is just... So he basically allowed the prosecutor, to argue the law. Prosecutor even said, I'm arguing the law to the jury, which in America is not supposed to be legal. In effect, now I think this jury would have convicted anyway. I think this judge wanted convictions, and I think he took a needless risk on appeal that now they have McMichaels and Roddy have a very robust appeal because the jury instructions were basically nebulous and unclear as to what's required. And the prosecutor did argue in close, and clearly the prosecutor didn't have confidence they were going to win, or they wouldn't have taken this gamble to reinterpret the statute. Given the statute's been scratched, it's not like it's a permanent issue.
That's an interesting thing. Like, in theory, I'm saying I said what I thought about the McMichaels from the beginning. In theory, they could have acquitted the McMichaels and say, well, that law doesn't exist anymore. So in as much as anyone thinks it's an unjust acquittal, the law no longer exists and we'll never have this problem again, which is sort of like, at the very least, from the tragedy came policy change. But I want to bring this chat up, Robert. Steve C. said $10 says, I know this is way out there, but what if the judge knew the jury instructions would induce guilty to avoid a riot and, knowing his ruling would be overturned, kick the can to the appellate courts?
The reason why I don't think that is this judge was pretty clearly hostile to the defendants all the way through. From the very beginning, the defense counsel was very adversarial to the court. I mean, to such a degree that the court scolded defense counsel for making faces at the court, that kind of thing. So there was clear animosity. And my view is that the court really wanted to make sure they got convicted, wasn't sure because of the way the evidence presented at trial that they would secure a conviction, and I think was willing to take a huge risk initially, even knowing it could have. But here's the other factor. The court also knows the politics of these kind of cases. Appeals courts turn a blind eye to bad law. So the very few people were willing to be publicly critical of this jury verdict. Many people on the right were eager to virtue signal in favor of the jury verdict. See, I'm not racist. See, I'm not racist. Look at me. In my views in ways that wasn't, I understand people who feel strongly on those first three factors. If home invasion doesn't really bother a person, if they think a state really should have monopoly or citizens shouldn't have arrest power, if they're uncomfortable with confrontation with guns, then they lean guilty all the way through. I understand those policy presumptions, but a lot of conservatives were just, frankly, in my view, eager to virtue signal to the world that they were against these guys based on a media narrative that was not proven at trial. And I have problems with the verdict. If I'd been on the jury like Bronca, I would have acquitted. I did not see. Well, what do I think really happened? Ahmaud Arbery was a career criminal who got caught. It's like one factor I thought defense could have hammered better in their closing. Arbery didn't start running when he saw the McMichaels. Arbery started running when he saw a neighbor on the phone. So why is he doing that? Because he's scared of somebody on the phone.
But this then goes back to the original interpretation of the law, is that, okay, fine. Even if he started running when he saw a neighbor on the phone, the McMichaels themselves they did not have firsthand knowledge of anything. What they had was rumor and supposition, as the prosecution said. And so when they were making the citizen's arrest, they didn't know what for, by their own admissions. They didn't know what they were doing. They just wanted to ask him some questions. And so they were not in any lawful position to try and effect a citizen's arrest. So how do you respond to that?
Well, in my view, they had definitely more than enough reasonable suspicion. One argument about the law is whether it's reasonable suspicion or probable cause.
Okay, yeah.
Historically, that law, it reads reasonable and probable suspicion, not probable cause. And the Fourth Amendment does not apply to citizens' arrest. That's not considered state action under Fourth Amendment analysis. So probable cause is not required constitutionally. It's a separate issue. They're being charged federally on the grounds that their actions were under color of law. That's in controversy within the federal courts. I don't think what they did was under color of law, but it's a close call because of how the civil rights laws are broader than the Fourth Amendment in its application. Deliberately so, because they were trying to get at Klan violence in the 1870s when they wrote that law. But I don't think that was, I think the federal criminal charge was over prosecution. But in this particular instance, what would constitute reasonable suspicion, or let's say the higher standard of probable cause for a traditional police officer? I thought, on Tim Pool, where Bronca did the breakdown, that if this was a police officer, he was pretty convinced nobody would have even brought charges, that it would clearly meet probable. To give an example, the Supreme Court has said you can have probable cause just by fleeing in a high crime neighborhood with nothing else, no other evidence behind you at all, just fleeing in a high crime neighborhood, running away when you see police or see anybody. That's it. They see a guy running, high crime, you can arrest. So
well,
that is.
Sorry, I'll get back to it. Just remind me of the comparison to police afterwards. But okay, probable cause, fleeing.
So in my view, and this is why it goes back to that core policy presumption, the law is written to give citizens more power to arrest than as a police officer. That's how I read the law. Now, one can argue about whether that should be the law. One can argue about whether that is the law. But that is a key issue in this case, because the way the law is written in its traditional interpretation, that's actually been the case for a range of historical and policy reasons. But in this context, what was their evidence that Arbery had committed a crime? They'd seen a photo of him inside the building. The neighbors had reported that he was there. Cops had been coming by identifying Arbery. They had seen Arbery before and had him cornered and then thought he had a gun and then backed off. And then they saw a neighbor calling while he was running away. If that was a cop, that's easy probable cause. So how is it not probable cause for the McMichaels?
But let me pause you there. Probable cause that he committed a crime when, though? Because from what I think all accounts are, there, even if it's reasonable suspicion or probable cause, the evidence was that nothing of that day, but rather from 11 days earlier. So
that's where escaping and the rest come in. Put it this way: if one of the tests I would do for people out there is reverse the racial identities, see if people respond the same way to the case, but also put cop uniforms on the McMichaels. Do people still have a problem with it? If they don't, then their real problem is a perception of what the law should be. And maybe it is what they think it should be, but that's in dispute, because otherwise they clearly had, if I'm a cop and or if I'm the McMichaels and I had the degree of information he committed a felon, the escaping provision is not immediate. The escaping provision is you're escaping capture for a felony that you've committed. And again, if we go back to the historical analogy, people won't like it for political reasons, but an escaped slave, you almost never see it. And usually it's days, weeks, months later. So, I mean, that's where the statute came from. People can dislike that statute, but once you understand that's its history, then it doesn't matter when they committed the felony. All that matters is they're trying to escape capture for a felony they've committed in the past.
Okay, so here's the deal. First thing, we've cracked 10,000 viewers live on YouTube and 1.7 on Rumble. One day, I would love to have as many thumbs up live as current viewers as we have. So let's see. I don't do the drinking game stuff or whatever, but we appreciate the thumbs up, although I don't really put much emphasis on that. This is my issue, Robert. I can appreciate the comparison. Put an officer's uniform on them, and if someone running in the street decides he's going to flee, and then, you know, after running for 5 minutes, however long, decides, you know, he's going to turn and try to grab an officer's gun, fine. Part of me says, however, on the one hand, officers would never have done what the McMichaels did, in that tailing for 5 minutes, pointing a shotgun at the individual before anything had happened. So if an officer pulls a gun and points it at someone in the absence of any reasonable purpose for doing so, I'm not sure that if a police officer behaved the way the McMichaels did, up until the moment, people would be so forgiving. A cop drawing his gun and pointing it at someone, as the McMichaels said they did, is problematic on its face. The other thing is, if it's an officer who's in uniform with a badge, and I don't think Arbery responds the same way. Same thing is if you have, you know, police in uniforms announcing themselves busting down a door, and someone in their house not returning fire. Okay, if they're plainclothes officers not announcing a proper knock and bash, or whatever they call it, comes in and the homeowner opens fire, fine. So that comparing them to officers cuts both ways. So I have to play with how I can digest that. Had they been officers, I don't think they would have been justified in doing what they did up until the moment. And sure, if a suspect tries to grab the firearm of a clothed officer and doesn't think they're being kidnapped or held at felony false imprisonment, that's also different. But I think the comparison has limitations, but I appreciate the comparison. So, I mean, that's the history of the law. You can argue whether or not you agree with that interpretation, but then what the judge did basically says, scrap that interpretation. This is how we're reading it. To which the defense said, well, then you're basically stripping us of the fundamental defense, and you've basically gotten to a directed verdict where you're saying this is how the law should be read, and our defense now fails as a matter of law. That's where the problem was in law.
Well, and then the judge walked it back. So the judge ended up not giving the instruction that the defense objected to. Instead, he just read the law, read the statute, and didn't clarify at all for the jury how to interpret that statute. So he played Pontius Pilate and just gave a very confusing, and this was Andrew Branca's criticism, law of self-defense, was that he gave a jury instruction that allowed the prosecution to argue the law to the jury. Now, my own view is that juries impose their own moral judgments on law anyway, so that was inescapable. But what the court did was create a very robust appeal issue. I think they moved for transfer of venue before trial. I'm not sure. This case is a reminder, like the Chauvin case, like the Kim Potter case coming up. Defense lawyers need to do detailed polling to prove the prejudice in a particular jury pool. The failure to do so will at some point become legal malpractice, because I think they could not get an impartial jury out of that region, out of that area, due to the racialized, politicized coverage of mostly a false story, false narrative. Arbery wasn't a recreational jogger or anything like that. He was a career criminal who got caught. Now, in terms of the police, my understanding is the only time, this again, just from opening statements and closing arguments, is the only time anybody pointed a gun at Arbery, that there are multiple times they could have that they didn't. They drove by him without doing so, so on and so forth. No evidence actually any truck actually hit him, as far as I understand from, again, the closing arguments. But the other component was that the only time that the gun was pointed down when he was running at him, and he brandished the gun for those purposes. But he claims, clearly the jury believes, that when Arbery ran around the truck and ran at him, that the gun was pointed at him. You couldn't see that on the video footage. In terms of my view, from my understanding of the evidence by the closing arguments, and this was not disputed by the prosecutor, the angle of which it was a 45-degree angle. That's not consistent with McMichael pointing a gun and pulling the trigger. It's more consistent with McMichael saying he was grabbing the gun when it went off. And so malice murder conviction tells you where that jury was going.
Well, we'll get to that in a second. And I want to bring this up. I don't read this as like a trolling accusation. This could be humorous, tongue in cheek. Viva just being contrary. I'm not. And I'll tell you something here. We had the same discussion in Chauvin. At the time, I said, look, I feel as though Chauvin, feelings, yes, over facts. Yeah, skip the Ben Shapiro lecture. I feel that something wrong occurred here. I don't know what crime I think Chauvin committed, but the way this unfolded, I think Chauvin committed a crime. I said the same thing about the McMichaels. The difference is that after having watched the Chauvin trial, I said at the end of it, regardless of how I felt from the very beginning, I, in my own mind, as a reasonably sensible person who has an open mind, there's reasonable doubt in my mind, regardless of how I felt at the beginning. And in Chauvin, I was prepared to say that based on how that evolution occurred in my own spirit and brain, even though I still think something bad was going on and something immoral, something potentially unlawful, they raised the reasonable doubt to me in the trial. In the McMichaels, they didn't. In the McMichaels, I still said, even if he were, and we said it from the beginning, and I said it from the beginning, even if he were a burglar, this was daytime, he was unarmed, they knew it, they had 5 minutes to tail him, they did not need to escalate, and we're going to get into a comparison of another situation. They did not need to escalate by getting, armed and heading in trucks or cars, I don't care about the car, and following him, getting out of the cars and allowing the situation to escalate. They could have found 50 other ways from Sunday to deal with this, and nothing I heard at trial convinced me otherwise. In fact, it actually sort of reaffirmed my belief because, Robert, I appreciate the video evidence, but McMichael, Travis himself said, I didn't know, didn't see anything that day. I pointed my gun at him. He was 20 feet away and approaching. So I'm not being contrary. I know when I have my preconceived beliefs, and I know when they can be changed, or at the very least where I can say, okay, despite what I believe, this is what was proven. In this trial, I setting aside the law itself, I know what they proved. The question then becomes, were they ever within their rights under any interpretation of that law to try to affect a citizen's arrest in the way they did, based on what they knew and what they thought they saw or what they didn't see at the time? And the judge effectively cut that plant off at the root, so to speak.
Only kind of, because again, he didn't clarify what the law meant. So he left it up to the jury to impose their policy judgments on the law. And so, he literally read the law. He just read the law. He gave no clarity at all. He just read it word for word. And it's like, look, there's already clear confusion because the prosecution has a radically different interpretation of that law than the defense. And the prosecution's interpretation is pretty novel. I mean, to my knowledge, that prosecution's interpretation had never been approved of by a Georgia court, and it goes against the canon of construction and the historical application of it. Also, if the court was even going to entertain that, the court really should have done that pre-trial. It's a bit of ambushing the defense to wait until jury instructions to say, you know what, I'm not going to give your jury instruction to the jury. In fact, I'm going to undermine it completely. Now, I think in the end, he did them a favor. I think he cared more about securing a conviction now than losing on appeal later. I don't think he was pro-defense and hoping it won on appeal later. Given his behavior throughout the trial, and the defense lawyers were clearly thought he was very antagonistic to him. I mean, there was open antagonism.
Robert, in fairness to the judge, you don't say we don't want black pastors outside the court during a trial that already has racial undertones to it. They did not allow the evidence of any ethnic slurs being uttered by the McMichaels after the shooting, but there was already that undertone to it. The defense attorney said some things which I think would have been questionable under the best of circumstances. So the judge's face did get very red a number of times as relates to the defense, but
it did. But that was Roddy's defense lawyer that was saying a lot of that. That was talking about black. He thought that there was efforts to racialize and politicize the case by people trying to be outside the courtroom and inside the courtroom for those purposes. I didn't like his terminology, but that is what it is. Now, some people seem surprised by the terminology. Like some people were saying that he was calling Black Twitter, and they're like, "What's that?" Look, that's a recognized thing. So the idea that doesn't exist, just like law Twitter exists, a lot of things. But but he was angry at the other lawyers who never made those arguments, and the antagonism was universal. Every defense lawyer didn't like him from the very beginning. So I didn't know what had happened in the lead up to trial, but I was like, you don't see that degree of antagonism between all of the lawyers and the court like that. So that told me that they thought he had helped rig the case in favor of the prosecution. And then his behavior reaffirmed that, in my view, at the end by his playing Pontius Pilate and not giving. He should have clarified that before trial. A fair judge does that. A judge who's trying to rig the outcome does what he did. And that's why I don't have respect for the way the court handled this case. I understand it's hot politically. I understand that the motivation, especially after Rittenhouse acquittals, was to get convictions then. Their timing, and right on the eve of Thanksgiving, bad luck for the defense to have jury. Anytime you have a jury deliberating for it, they're thinking, I want to get home for turkey and take the next day off. I don't want to come back here. So, and then it's after the Rittenhouse controversial, the shouldn't have been a controversial verdict for Kyle, but the way the media portrayed it, it was. So that judge is under maximum pressure, and it doesn't help when Jesse Jackson and Al Sharpton are in the courthouse every day. So reminding everybody what this case is about. And this is the South, where Kenosha, very small African-American community. There were no black people shot. I mean, there wasn't really risk of racial riots from Kenosha. There was real risk of racial riots in Arbery because especially the way the media narrative had built, it was these, Klansman types chase down random black guy for being, black while jogging and shoot and murder him for no reason. That story was not true, but it's the one a lot of people believed. And so the probability of that case going up in flames was really high. So I understand why the judge felt the way he judged, and I think that's why he kept the case too. I think that's why he didn't move it. He didn't move it because he didn't want to be accused of helping these people get off. But I don't agree with the verdict in terms of the evidence adduced. Now that's heavily based on my interpretation of the statute. If the prosecution's interpretation of the statute is ultimately affirmed now again, this is a point that Bronca made. The rule of lenity is that in a criminal context, any ambiguity should be interpreted in favor of the defendant for constitutional due process purposes.
Say that word again, lenity?
Yeah, lenity. So the rule of lenity, Lenity, is that for due process, you have to be on fair notice as a defendant what you can go to prison for. And if there's any ambiguity in the law, the ambiguity has to be interpreted in your favor. Clearly, the law was sufficiently ambiguous at a minimum that it should have been interpreted in the defendant's favor. And again, as it turns out, the judge jumped the gun because this jury likely would have, when you convict within a day and you convict of malice murder, and then you convict on the guy who just made the mistake of sharing information with the police. Because, the only reason this case ever blew up was because Roddy decided to tape it with his phone. And my view is a guy who thinks he's committing felony murder doesn't tape it and give it to the police.
We're going to get to that right now, but the flip side to that is ignorance of the law is no excuse. But we'll get to that in 1 second. I just want to, pull up some needles here. Let's get Ben Shapiro in here for the Facts and Feelings lecture. My appetite for hearing about Viva's feelings has been, I think, maybe satiated or sated. And then if I think I missed one more, but here, the jury definitely said, screw the other. Well,
yeah, they did. That's exactly what they did. I know if you agree with the prosecution's interpretation of the law, or if you deeply disagree with some of the policy issues surrounding that law and think it should be interpreted in that way or must be, then I understand supporting the verdict. I don't, because I don't agree with the prosecution's interpretation of the law. And I think that, and it's also just a big culture gap. Where the other risk for these defendants was that, there's a part of the country that for whom the state having a monopoly on the use of the violence or the use of arrest power is not okay. But for other parts of the country, it is. I happen to come from the belief structure that I'm not in favor of the state having a monopoly on that at all. I'm willing to take the risk that people will make mistakes trying to arrest people over the risk that criminals get away scot-free, or over the risk that the state gets to keep a monopoly on power. I'm for the state having as few monopolies on power as humanly possible. But that's a philosophical belief that informs my moral judgment of them, which in turn shapes my belief on the verdict. And I think this would have been true for anybody that was in that jury pool. So I don't think they got an impartial jury. I don't think they got a fair judge. That they do have robust grounds for appeal. I think the politics of the case will make an appeal more difficult than it should be.
All right, and then getting into the convictions, because look, everyone made predictions. I think the outcome was sort of splitting the baby in the sense, except it's all life in prison anyhow, which is the issue with felony murder to begin with. A chat earlier said, how do you get 5 murder charges out of one incident? Other people are saying, all right, how do you get malice murder? Now, let's start with malice murder. Malice murder, it's premeditated. It's premeditated. It's another word for premeditated, unless I'm oversimplifying. premeditation doesn't mean you sit at home calculating yada, yada, yada. Premeditated could be within a split second moment. He said, yeah, I've got an opportunity. I'm going to do it now. So, I mean, McMichaels, Travis, how do they get to malice murder? Ultimately, it makes no difference because give him felony murder for, false imprisonment leading to death. He's still getting life in prison. But how do you get to malice murder in this case? And if you know, how has malice murder been applied in Georgian law?
So it's like considered one step below premeditation, that it's like that you intend it, a few seconds before you do it, that kind of thing. So they clearly believed the prosecution's theory, and were just very anti-McMichael in my view, or anti-defendants in general. That's also reflected in the time. Any jury that's more concerned about Thanksgiving than getting a verdict right is not the best jury. Is my view. There's a lot of lawyers that always say nice things about juries. I do not. Juries are just like all human beings. They're as good and as bad, as smart and as dumb, as honest and as dishonest, as honorable and as dishonorable as the rest of us human beings. Their virtues and their vices are the universal to humankind, and we shouldn't glamorize them or make them more heroes than they are. This was a lazy jury that wanted to get home for Thanksgiving that didn't take its oath seriously. And I have no problem being critical of them. Because there needs to be more criticism of bad juries because there's not enough of them. We have way too high a conviction rate in this country. Any system of justice should not produce 80, 90% conviction rates. That's the risk of human error is simply too high for that to be the case. And so that is evidence that we have prejudiced juries in general, and we do. But but in this context, they clearly believed the prosecution's story that when Arbery turned, that McMichael had the gun up and shot him right away. That's the only explanation for that. That he was waiting for him to get within clear eye shot, and he just deliberately shot him. Again, that's not consistent with the evidence at all. So that's what I mean by they wanted to convict. They wanted to prove their virtue. They wanted to go home and get turkey. And that's why I didn't have. I can't credit the jury for what they did.
And I'll say this: despite what I feel about the trial and what I think about the McMichaels and what happened and how it escalated. Malice murder, I mean, a good argument is that was not Travis's intent from the beginning. He had 5 minutes to do that earlier if that's what he wanted to do. That being said, and which is why I say, I think there was a crime committed. I don't think it was malice murder. That's why I didn't predict it. I could easily predict felony murder because they were clearly, by the evidence that I saw, committing a felony, which led to a death, therefore felony murder. So, but the outcome is the same, Robert, right? The max, is there a minimum sentence on felony murder or just a max sentence?
You have pretty broad discretion as far as I know in Georgia. So, but I think we'll see whether I'm right or not about this judge when sentencing time comes. Watch for the sentence to be on the high side of the equation. I said that about the Chauvin judge. For everybody. You watch it be for everybody. For Travis, he'll do the max for everybody to make the point of which side he's on. And so that's my read on this judge. And so I think that now I think he'll second guess the wisdom of him taking a gamble on the jury instructions once that jury came back so quick. And I think that's it. I mean, to the question, it all depends on what the citizen's arrest statute is to all of it, because their explanation was they weren't trying to actually physically arrest him. They were trying to keep him within the neighborhood so that he was still there when the cops arrived. And most of their conduct is consistent with that. You can argue about the very end, whether the very end is consistent with that, but the rest of their conduct in the minutes leading up to it is consistent with that. But from a false imprisonment perspective or attempting false imprisonment perspective, the issue is all you have to do is try to restrain him. And they did say try to restrain his freedom of movement. Like, I looked at this under a Fourth Amendment standard. I don't know if he would be considered arrested or not. You're considered arrested if your liberty is restrained. I can tell you under even more onerous circumstances, courts have said no arrest. So it's interesting that this was an arrest. At least there, it was a false imprisonment, which is the same standard. Your liberty of movement. You believe your liberty of movement is restrained as an individual. In this case, you're intending to restrain the other person's liberty. Now, they were charged with 3 felony murders, aggravated assault, and false imprisonment and attempted false imprisonment. I didn't think they met even the basics of the first 2. The question was on the third was definitely the citizen's arrest statute. Now, they got convicted of all. Well, not the The gun charge, they let the guy who filmed it off, but convicted him of everything else.
But so,
and again, he tapes it, he shares it with the police, somebody leaks it to the press. That's how they ever got prosecuted. They never get prosecuted if he doesn't both tape it and share it with the police. If he had never done that, he never gets prosecuted. So it's a reminder to everybody, don't ever volunteer information to the police. They're not there to help you. Ultimately, they're out there to hurt you, and that's what happened here.
well, I mean, look, some people are going to say, does it matter that he didn't think what he was doing was wrong? He thought he was helping. He's the only one that in my prediction on Twitter, which I don't delete afterwards, I said, he's got the best chance of getting off. He didn't get convicted of malice murder or felony murder on the gun charges, but on false imprisonment. But Robert, so the max sentence is the max. Is there a minimum required sentence, or could the judge say, okay, for Travis and Dad, you're up shit creek, but for film guy Bryant, I'll go easy on you? I mean, is there a minimum that's required by law, or could the minimum for felony murder for the false imprisonment be nothing? I presume there has to be a bare minimum.
Oh yeah, there usually is. I don't know all the Georgia sentencing laws though. So okay. My guess is he'll go high on all of them. Just because I think he was trying to make this became a political case. It was really only prosecuted for political reasons because of the press narrative. I think if Arbery is white, there's never a prosecution. It's never a press story. I think if the McMichaels or Roddy were black, I don't think they're ever prosecuted or a story. I think if they were police officers, they're never charged, and that by itself makes me have problems with the prosecution. And then by what I saw at trial, given my interpretation of the law, they were in fact within their lawful rights to attempt to detain him while police arrived, including to use force to do so. And I believe Arbery was a caught criminal that day and decided to make a bum rush to get himself out. And what he would have done with the gun, who knows? He kept punching at him even after he'd been shot. But Arbery had a history of that. Now, all that history was kept out, but Arbery had no problem confronting police when caught. So I don't think Arbery would have reacted any differently. It's who he was. He's a career criminal who didn't like getting caught, who was confrontational when caught. That was there. Now, like, one thing that probably hurt the McMichaels is that the police apparently had advised that they thought Arbery was armed and not to try to follow him. If the problem for the neighbors, and this is where it comes back to that, how you feel about home invasion and burglary. The neighbors' frustration was that they thought Arbery had been doing this for close to a year. There had been 90 police calls in the months leading up. Arbery had been spotted about half dozen times in the neighborhood. There had been a range of thefts in the neighborhood, and yet the police never caught him. And I think that was their frustration, was you have this community that feels more and more agitated and irritated. And I think a part of the reason for this prosecution was to give the state a monopoly on the use of force and scare people into not using force themselves, and to not trying to arrest people. And there it depends on what your policy judgment on that is. How you feel about that ends up shaping the people's perceptions of the justice, whatever they think of the law, the justice or injustice of the verdict. But for me, I didn't think it was a just prosecution or a just verdict.
Now, Nate, the lawyer, by the way, Nate, in the house, thank you for being here. Robert, you're incorrect, although I think that's leading it. 90% conviction rate includes
Yeah,
plea.
Nate's wrong. Nate's way wrong. It depends on which cases he's talking about, but I track this data in great detail.
I would have said one thing. Even if it is 90% including pleas, Robert's not wrong. You're just interpreting the stats differently. But
it depends on whether you're talking about certain state charges and federal charges and what kind of charges you're talking about. But you can look at jury trial conviction rates in the federal system, and it's over 80%, and in tax cases over 90%. So in the state system, it can go as low as the 60s or 70s. Now, maybe in New York, it got to 50-50. But that would be unique to New York. Generally speaking, it is very hard to get acquittals. Now, if you count all charges, maybe, right? Like if you have 12 charges, you get convicted of 6, but any of the 6 put you into the same time as all 12, then maybe it's 50-50. But in terms of going to trial, securing a conviction in the federal system, it's over 80%. It's over 90% in most cases on the federal level in tax cases. And then on the state level, it's anywhere from 75 to 90%. The lowest it gets is certain kind of charges that have in bigger jurisdictions that have good defense lawyers, you might get into the 60s. But I've never seen it be 50-50 anywhere in America. So if he's got data for that, I'm happy to see it.
All right, and now I'm going to say, Ryan, if you have diarrhea, I suggest chicken soup with rice. Just my grandmother's secret recipe. Okay, I think we've covered this, but this is a good segue into the had the races been reversed, or et cetera, then it might have been different. We're going to get into it because thus far, in a situation where the races were not reversed, but the races were consistent, homogeneous. They were the same. That's probably the easier way. We're going to call him Carruthers because I don't want to call him Kyle because it carries the baggage of another situation. The Kyle Carruthers having shot Chad, and I forgot his last name, and it's not to be disrespectful. And I think Chad Reed. This made, for whatever the reason, I don't know why it got popular in terms of media this week, because it didn't happen this week. It happened a while back, a short while back. For anybody who doesn't know, this is another shooting, Lubbock, Texas. It starts off as a family dispute, a father who's getting divorced or who has been divorced, picking up a kid for visitation or for his, I don't know the terms. I never did family law, but picking up the kid for his time with the kid. Kid's not at the place where the kid is allegedly supposed to be at, where he's told to pick him up, which is the house of the now boyfriend of the divorced mother, who is Carruthers. There is Chad Reed getting irate, and I say that without judgment. I've seen enough family stuff to know how people get irate, and rightly so, sometimes wrongly so, and just sometimes because of the circumstances that are beyond them. Gets irate, says he's going to sue, subpoena, bring everyone to court. Kid should be there. It's not up to the mother to go bring him to where the kid should be at the time where it's him to have his time with the kid. Carruthers goes into the house, apparently after having asked Chad to leave, but I didn't get that from the video. Went into the house, comes out with a carbine weapon. I'm going to need clarification on what that means because I've read the distinction. I still don't understand it. Comes out with a carbine rifle, shouts leave quite loudly, which I'm not saying provoked because that's a legal term. But when he comes out with the gun and says leave, Chad gets up on the porch, chest bumping. Carruthers fires a warning shot to the ground at his feet, which, if you haven't watched the video, go watch the video. It might make you a little sick. But when you see these guns go off and you expect recoil, you expect smoke, you expect like Die Hard type special effects, it pops off. And I didn't even know that the gun had popped off in the first few times I had seen it. I had to go back and see when this happened. Shoots a a warning shot at the feet, which causes Chad to throw or shove Carruthers off the porch a few feet away. They're separated. Some say 10 feet. I don't think it's 10 feet. I think it might be closer to 6. It doesn't matter. Anywhere between 5 and 10 feet. Carruthers gets pushed back, fires twice into Chad, who is standing at that point between him and his house, which is when the carbine issue comes into effect, because apparently people are saying had that been a rifle, the bullet would have penetrated and potentially gone into the house and hit whoever's in the house. I don't know how these things work, but that's the circumstance. If I've left anything out, it's not for malice or intellectual dishonesty. It's just because presentation. First of all, why did this not become known beforehand? Like, how did this only come about now? Do you know any of that context?
My understanding is the footage was only released this week. That's why.
Okay.
So I don't know if there was like a FOIA request or something that triggered that footage being released, but my understanding is the footage was only released this week, and it sort of triggers a broader social conversation. Now, it's Texas, so I have a different interpretation than I've seen from a lot of other people out there, as has been explained to me many, many times by my Texas friends. If you use force to get on somebody's porch, they can shoot you. I mean, they just explained this. It's Texas. Texas has the broadest self-defense laws in the country, and it includes broad self-defense of just property. But in particular, your habitation includes not just the inside of the home, but includes the garage and the porch. And critically here, if you use force to get onto somebody's porch, who has told you not to be there, you don't have a lawful right to be there. The moment you use force to get on that porch, they can shoot you in the head. You've just won a Darwin Award. And that's what Chad Reed did. He won himself a Darwin Award because when when he gets up, he jumps on the porch, does the whole bumping in the chest. That makes sense. That the Bronx is
Sorry,
different.
I could not let Nate get away with. I mean, he put it up, so he's owning his understanding of it. But Robert is right. I looked up the stats in the Bronx where I worked. It's 50%. It is 85% in feds in most of the country. Okay.
And that tells you you had certain unique jury pools. You can get to that. There are some rural counties in the country that are interestingly like the Bronx, but it's justified from the TV show based on the James by the Elmore Leonard book.
I'm
That's
going
that kind
to
of part
say good
of the
on
country
both because Nate made a statement. Robert, good on Nate for making the statement. Good on Robert for knowing the facts, and good on Nate for being able to say yes. You were right, more broadly speaking. Sorry to interrupt you there. Yes. So what's the word for the
apparently Reed, assuming these facts are true, but what I saw Reed get on the porch. Apparently said, after the other guy comes out with the gun, Reed's reaction is to be aggressive, go up onto the porch, apparently say something like, "I'm going to take the gun," or "You're not going to use it."
Yeah, I'm sorry. That's a material fact that I forgot to mention because I heard that the first time, and I don't know where people think I'm going to land up on this one. Reed said, "You better mother effing use it because I'm going to take it from you and use it on you." Right. And he said it, and then he tried to grab it, and that was before the shot into the ground.
Yeah, well, X tried to grab it apparently twice. He grabs it first, and then there's the warning shot. Then he grabs it in such a way that he basically throws the other guy off the porch. And as soon as the other guy's off the porch, he fires twice. Now, I get that, Andrew Bronco's view was when he's thrown off the porch, he's a sufficient distance that he no longer has traditional self-defense. That may be true. It's all about timing. But in my view, under Texas law, it doesn't matter because what has just happened is that Reed has used force to enter the habitation under Texas law. He's used force to enter after he's been told to leave. He's used force to be in the house. Being on the porch is considered in the house. And under Texas law, you're allowed to presume that he is a deadly threat at that point. And I would note, you see in the background something people haven't highlighted, but it looks like an older woman is trying to quickly lock the front porch door that also ended up taking a video with Reed only a few steps away after he's thrown the other guy off the porch. So that may be the concern as the grandmother in the house is my assumption. I could only see a glimpse of it. But my understanding of Texas law is once he did that, he won himself a Darwin Award. He had the right that at that point he had the lawful right to shoot him. And that's not most states. That's Texas. But I would say in places like Lubbock, guys like Reed, now apparently he was a felon. Apparently his ex-wife was a felon. So that may be why he didn't have a gun. That if he was a felon, that federal felon, is my understanding he might have been not allowed to have a gun. So he might have actually been committed another felony by saying he intended to get that gun from him. That's another issue. But my view is in Texas, once somebody uses force to enter your porch, as he did the moment he threw that guy off, he had a complete self-defense right. So I don't think that they'll prosecute. And I think if they did, they would acquit. There's a lot of those kind of acquittals in Texas. This granddad walked out once and saw a couple of thieves stealing something from the neighbors, and he just shot him right there in the front yard. And he said, why? He said, well, I thought they were going to rob my house next. Full acquittals. I mean, it's Texas. It's a different world down there. But I'll tell you, if you're Chad Reed, by golly, you know that. So you decide to be macho and jump a guy and jump a gun on his own porch, brother, you got it coming. That's sorry. That's the end of it. Sad, tragedy, but, I can't quite feel too bad for him.
I'll get to what I think in a few. I just want to read some of the Rumble rants on Rumble because we have a few now. It says, drink from Zom God This World. It's a long name. Keep up the good work from Noifub. Now, but this one is relevant to the question. It says, did I miss anything? Christo a Fish says, so much. Chad says on the video, he had the cops on the way to the ex's house because he did not expect Kid to be there. Carbine is a shorter rifle. Caliber is not really a factor. The carbine, Chad, is a 9mm. So I pulled up the other comment here that explained what a carbine was. And this is from Christopher Fish. Says caliber is not a determining factor for a carbine. A PCC, pistol caliber carbine, is a type of carbine. Carbine is simply a shorter rifle. Okay, now and then Robert, speaking of where I'm curious as to what people think I think of this based on what I've seen. I've watched that video more than I want to. I've listened to Law of Self-Defense, Andrew Bronca. I've listened to Legal Mindset. And I know people are going to say, you know, when the guy comes out with a gun and says leave, and you don't leave, if you don't have to leave because I think my kid's there, you know, what of that? My reflex is when a guy comes out with a gun and says leave, I'm leaving, no questions asked, and I'll call the cops later if I think so. But beyond not leaving, then getting up and chest bumping, and then at one point trying to grab the gun. And now I've been sufficiently versed in what is the applicable law, and he did it twice. And a lot of people are saying, well, or say Andrew Branca's take is that it might be manslaughter because at the time they were separated by 6 to 10 feet after Reed threw him off the porch using the gun itself or the sling. He was not an immediate threat. You know, again, we're in a situation where it's 2.5 to 4 seconds at best between beginning and end. And
the other thing is, Bronco would be right, but for Texas law, my understanding of it, if he had not used force to be on the porch, if he was still off the porch, then you have an issue about the timing. In other words, whether or not it made sense to pull the trigger about a half a second after he gets thrown off, is my understanding. But basically, it's almost immediate. But I could see the argument that it could go to the jury, but not that he was on the porch and he used force to be there. And my understanding that's that for Texas. I mean, if somebody sees you, the reason why they include the porch in Texas is if you see somebody trying to get into your house, trying to get into a window, using some sort of force to try to get in,
typically
they want you to be able to use defense, self-defense. It's most states do not have. I think Texas has the broadest laws of self-defense in the country. Last I knew.
Well, I would suggest,
plenty of Texans remind me of this. So.
No, I would suggest also the idea of extending any protection to the porch is that in some, in cities, you don't have a porch around your house because you don't have the real estate to justify a porch. To say any protection does not include the porch in areas where you will necessarily have a porch, and in order to break and enter, you're necessarily going to need to traverse the porch. I understand that. And Eddie Oliver says, nobody in Lubbock would convict Carruth for defending his home. Also crazy as it sounds, if you assault someone on their porch, it's burglary in Texas. You can lethal force burglary. Look it up. No, I mean, you could go watch it, a lot of it. My issue was, and I was surprised, is when Chad said, you better mother effing use it, or I'm going to take it from you and use it on you. Some interpretation said that a verbal threat was not any significant or justifiable threat to warrant any escalation. It was just a verbal threat. It's not worth more than that. That surprised me. But even if that's the case, the verbal threat coupled with the actual act, and anyone wants to do the seconds between trying to grab the gun the first time and the warning shot and the 2 fatal shots, I may think that somebody was out there looking for a reason. And then I might also be thinking that someone was out there giving them a reason and thought they were not going to do it. But
I mean, I think you could even argue he used force when he got up on the porch and bumped him. Whether that's force or not, I mean, it kind of seems like it. But there's no question he used force when he grabs him and throws him off. Effectively, uses the sling to do it. That's clear force.
And then the question
is considered force if you're trying to use a screwdriver to open the door. So I mean, that's clear force. And as soon as he did it, and maybe that guy knew the law. Maybe he knew. He's like, okay, boom. We're done.
That's it. And me and my Canadian side would say, okay, well, you're off the porch now. Go back. You don't need to escalate. Back up. Call the cops, and then hold him there at gunpoint. Someone's going to say there's no duty to retreat in Texas, and he doesn't have to do anything to escape. He pulled a gun. He fired the warning shot. Sorry, actually, before I forget, some people saying firing the warning shot itself was a felony. Robert, I don't know from a hole in the wall.
In certain circumstances, it could have been, but I don't think in those circumstances it was. Also, there is a question because of the nature of that gun has a history of accidental discharge, whether that was a warning shot or accidental discharge, unclear. So but at least and then the only question would be whether the warning shot is the kind of removes his self-defense after he's being thrown off the porch at that time. Because there's a problem with, felony murder has to have a but-for causation. But for the felony, the death doesn't happen. Here, there's clearly an intervening event, his action to throw him off the porch. And he initiates that whole thing, too. It's not like he does a warning shot out of the blue. He jumps on the porch, says he's going to take the gun. You better use it or he's going to take it and use it against him, and then chest bumps him. I mean, that's entering the home illegally. in Texas. As soon as he did that with any form of force, he's forfeited the right to life in Texas.
No, and Elliot Smith and others are saying, I'm not, this is not to pick on. His feet look to be off the porch when the shots are fired. You can see in the video from inside the house. Yeah, in the split second, so he's on the porch, he's off the porch. He had just tried to grab the gun. He had just thrown Carruthers off the porch with the gun. I gotta say, this, what depresses me about this entire situation, it looks like a guy with a gun looking for a reason, and an irate father who's frustrated at the family law system, in a moment of rage, gave him the reason. And it looks unjustified. But if I come out of a house with a gun and I say leave, and the person says, you better use that on me, mother effer, I'm going to take it from you and use it on you, and then goes for it, if it's 6 seconds, 8 seconds, 2 seconds, or 10 seconds, if it's not 2 minutes where the guy's like running away saying, I'm sorry, I know what I would think. So
yeah, I mean, he decided to break the law in Texas and be aggressive and risk his life, and he lost. I got no sympathy for him. Now, at my own view is I'm sure there is a backstory here. The interaction between he and I was not sympathetic to his version of events by what I watched. Now, facts may prove me wrong in the end because this is just on the interaction. But the guys that obsess over 3 o'clock versus 6 o'clock, that's a history of, that's not always about the kid. That's about, their anger at the ex-wife. And maybe the ex-wife is playing games, but at the same level, you go to court to deal with that issue. At this point, he knows that. You don't do what he did. Number one. Number two, the way he interacts with her, I've seen that before, and it struck me as an abusive personality.
Yeah, and that's why
he's walking aggressively, and she's backing up. So it wouldn't surprise me if there was a backstory here. And then so you have the boyfriend coming out trying to get him off the property and defend his girlfriend, that person's ex-wife. And that guy's reaction is to jump on the porch, say, you better use it or I'm going to kill you. Twice try to grab it, and the second time throw him off the porch. Sorry, I have no sympathy for that guy.
I have sympathy, but I definitely see if I'm the guy and I say leave and you don't leave and you get up and try to grab it, and then the argument's going to be, well, after he threw you off the porch via the gun or the sling, and you had 6 feet between you and him, your window of opportunity had left. As sympathetic as I am, and I am, I think I know what I would do. The only question is, it's the philosophical question. When everyone has guns and you run in to get a gun, does it provoke the attack? Does it escalate a situation that would have never gotten there? And that's the question is Robert, is this provocation in the sense of that lawsuit or the case that they referenced in Rittenhouse where the guy goes out to his car, gets a gun, and then goes back to the bar? That's provocation. A guy going into his house, getting a gun and coming out on his porch and saying leave, is that provocation?
Definitely not in Texas. In fact, it's explicitly lawful. So, again, I mean, that's Texas. And that's the other thing is the guy knows Texas culture. It's not like he's a New Yorker who doesn't understand or something. So
Robert, I'm a Montrealer. I understand. When I see a sign that says no trespassing or trespassers will be shot, even if I don't see the sign, I ask the question, am I on somebody else's property right now? Might I stumble across something that the landowner here might not want strangers to stumble across? I ask myself these questions all the time. I would have been out of there. I would have never, whatever. But the entire dynamic was very, very surreal in that video. And I got to say, what I find the most surreal about it is how uneventful it all is. It's not like Squid Games when somebody gets shot in the first scene of that show, the game, red light, green light. It's people don't fly, squibs don't go off. It's almost shocking in how uneventful it is. It's just pop. You don't even know the gun goes off, and the dude doesn't fly. He just drops like a sack of potatoes, and a life has been snuffed out because of a broken system that leads to escalations, and then a dude who's enraged in the moment and thinks this guy won't pull the trigger, and the guy pulls the trigger. So predictions are no charges, and if charges, acquittal. And those are your predictions, Robert?
Yeah. And I would be surprised if he got charged in Lubbock. I'd be surprised at that.
And I'm going to say, despite how I feel about this, despite my moral conundrum, but despite my emotions, I don't think he's going to get charged. And if he does get charged, he's going to get acquitted. That's my prediction, despite how I feel. So everyone out there wants to say that I'm a little, snowflake Maple Leaf Canuck. That's how I feel about this. It's a disgusting situation. It should never have happened. But the way it happened, that's my prediction. Robert, what do we move on to? Ghislaine Maxwell, speaking of judges. And okay, sorry. First things first, Robert. Tweets, social media, gag order for the trial. Do you know of any official gag order, or are we dealing with misinformation right now?
Yeah, I mean, I don't know of any gag order. So I know that the trial, all federal courts refuse to allow any video cameras in their courts. To my knowledge,
Why?
no federal court has ever allowed video cameras in their courts.
Why is that?
It's because it comes from the U.S. Supreme Court. So the Supreme Court of the United States thinks it will degrade judicial proceedings to allow them to be camera broadcast. I think that the problem with that interpretation is there's a constitutional right to public access to judicial proceedings. Trials were originally held out in the open without any courtroom, so the whole community could witness. So I think it violates the right to public access to the criminal process. It actually leaves people less informed. Here's what judges think. Judges think everybody will be parading for the camera and it will undermine the holiness of the judicial branch and of their courtrooms, because it tells you how they feel about courts. Well, one of the great lessons I ever learned was when I clerked for an Indian tribe in Wisconsin that was designing a new court system because they had so many contracts with their casinos with non-tribal members. They wanted a court system that blended tribal law with American law so that the outsiders, the vendors, the employees, the non-tribal members would go to a court system that was familiar to them, even though it was being governed by the tribe, while at the same time not offending or upsetting tribal members, because these would be disputes between the tribe and non-tribal members. Any dispute between tribal members, they could pick either this court system or the elder system, and they almost invariably pick the elder system. But what's fascinating is we just designed the courthouse to have the judge be above everybody else, like all American courts are. Tribal members, that enraged them. They were like, "What in the world are you doing up there? You should be at the same level as us." And I remember thinking, wow, I had never even thought of that in the history of American court system, that judges should be at the same level as the rest of us. And I thought, yeah, absolutely, they should be. But it reflects the court's high esteem of itself, where we're so holy. You're walking into the temple of temples that we can't allow something as crude as a camera in our courtroom.
They are the law, Robert. Fauci is the science. The court is the law. But the question is this: some people say, I don't say conspiratorial reasons. They say it's to protect the state or to protect the federal government. But how does that argument apply more for federal courts than for state courts? If the goal is to shield the government, you'd want the same protection at both state and federal level. So why would there be a discrepancy?
Yeah, no, I mean, that's not why. The federal court, they do this universally. Now, you can argue that video cameraing taping and broadcasting the proceedings would expose problems with our federal court system, and I would agree with that, and that may be part of their motivation. They don't want the judiciary to look bad. They don't want prosecutions to look bad. They don't want government actors to look bad. That could absolutely be the case. But it's not their formal or official motivation, and honestly, I don't think it's their driving. These people have too high a value of themselves to recognize that they might look bad on camera. That these are people who just it's beneath them to allow something as crude as court TV into the courtroom. So it's not unique to the Ghislaine Maxwell case. It's universal.
Okay, and good. Now, so Viva, if he had said please, would you have left quick? Dude, when he says leave, if he doesn't say please, I'm leaving quicker.
Well, I don't go wandering into other people's lawns, and I don't go wandering into other people's porches. Even if I got a dispute with them, I don't go, especially if I was in Texas. That's why I got no sympathy for playing Darwin Award winners.
No, but the flip side is, Robert, someone's going to say there was a court order ordering him to pick up the kid at that address at that time. So
and then you even more so, not to do that, because when you do that, you're going to undermine yourself with the court, because you're creating confrontation, you're creating problems, you're calling police. You simply document it. You go, and at the point that this father had been involved in proceedings, he knew that. Yeah, he wanted to prove who he was. That is the way I take it. Again, I could be proven wrong. Maybe there's a backstory that's different. Now, my understanding is she was also a convicted felon. I don't, again, I've only seen one headline that said that, so I can't confirm it. But my understanding is both he and the ex were. So you're not dealing with charmers here.
Okay, and that might explain the absence of reaction from what just occurred, because okay, so that is not the reason for which the federal court does not broadcast versus the state court does. And to confirm, Robert, neither you nor I, above and beyond some tweets saying gag order, none of us have seen it. There is also an image, a link going around, a call-in number for tomorrow. I might try to stream this, and I'm gonna have the phone on my ear, not to broadcast it live, but I'll just be talking as we go, depending on what happens tomorrow.
You should be able. Usually, they are allowing in the pandemic era more and more either Zoom or other audio broadcasting of federal court proceedings. I don't know of any federal court that's allowed any video proceedings public. Now, I know there's been some court proceedings allowed some video Zoom appearances, but even in those contexts, they have not allowed the public in. But they have allowed the public in on audio. And so my understanding is that they are going to allow there's going to be an old school radio broadcast effectively through a phone number you can call in on and listen in. You obviously can't talk. It's simply a broadcast, but that it may be live broadcast on audio terms. That wouldn't surprise me.
I'm not streaming the audio, because even if it is being streamed, re-streaming it or rebroadcasting it will probably be unlawful. So what I might do is
it would be lawful. It would be okay if they do that.
I'm not taking chances, Robert. I don't want people making Epstein or Clinton jokes about me. So I may or may not.
Let Nick Rekieta be the test and let see if he survives.
Oh boy. No. So that, just sort of. So you should be able to hear it if you want to, and it should be done. It's going to crash. The system is going to crash tomorrow, because they're going to have more bandwidth requests than they can deal with, but we'll see. But so that out of the way, it's not being hidden in any nefarious sense, although they might be exploiting of the rules to hide it.
They're hiding it different ways. The way they're limiting evidence
Robert.
is the prosecution has limited what they're going to present. That's the number one key. And the defense has limited what their defense is going to be. And the timing of the district court judge being nominated for the Court of Appeals while this trial is ongoing and was planned at the time is, to me, further indicators that the judge is going to be rewarded for keeping the evidence limited at trial. Make sure this case doesn't go certain places. Now,
I'm still wet behind the ears, naive noob. I said, okay, fine. Judges get appointed all the time. Setting aside everything that relates to this particular judge, Allison Nathan, setting aside all the other secondary stuff, the judge gets appointed to the Court of Appeal by the Biden administration while the trial is going on. Explain what reasonable people could have by way of reasonable suspicion as to why the appointment is problematic, to use a Scott Adams term.
They can go back and study the Daniel Ellsberg trial, the Pentagon Papers case, where the Nixon administration was back-channeling with the judge that as long as he's helped secure convictions, they were going to make him head of the FBI. So there's a history of this happening. And the timing of this looks really bad. The timing of this looks like here's a carrot. If you make sure this trial goes right, you're going to be up on the Court of Appeals. That's the way it looks. And frankly, I think that's exactly what's happening.
But to be the contrarian, Robert, she's already gotten the appointment, so there's no carrot anymore. She's been fed already.
I don't think her appointment's not been confirmed. She's been nominated. It's my understanding. If it had been confirmed, she wouldn't be presiding over the trial.
Everyone, how does that black pill up the butt feel tonight? Just so everybody can appreciate. Now, okay, all right. So do good, and you get that appointment. Robert, for those of us who are not sufficiently black-pilled, who now have had this jagged suppository injected into their persons, what's the practical benefit of being on a federal court versus a federal court of appeal? Remuneration, benefits?
Not so much. It's purely status. So, I mean, you have more power to a certain, well, kind of, depending on how you interpret it. You have certain kinds of power in a district court because you're the only judge, and a lot of decisions you make are never going to be reversed. But status-wise and theoretically, you're one of three on a panel at the Second Circuit Court of Appeals, but it's a lot more prestige and theoretically more power. It's less because you're one of three to a certain, but your decisions have broader precedent. You govern a lot more than just your little district. So most judges want to go to the highest court they can. So because most of them are driven by status, generally speaking, or the good version would be they're driven by they want to make the biggest difference. That's the nice version.
This is why I feel stupid right now, Robert, because I did not even make the immediate distinction between nominated versus appointed versus confirmed.
Mhm.
And now I feel like an idiot because now, God damn it, now I actually see the actual, the hint, the flavor of corruption.
Yeah. I mean, it shows you how non-bashful they are. You know, they eternal truth. Number one, Epstein didn't kill himself. They didn't care about that. And then here they make sure the trial goes in a certain way. And my understanding is James Comey's daughter is one of the key prosecutors. So what's the likelihood? I mean, how does that happen? How does James Comey's daughter end up assigned to this case?
Robert, I'll play devil's advocate. It's a small world. They're all interconnected. You know, if you'll find a connection anywhere you go in this world of Washington and federal prosecutors.
And this is the same prosecutor's been promising there's ongoing grand juries and there's all these co-conspirators that are going to be named. Where are they? Why haven't they ever been named? I think they're going to limit this case to just a few places. Probably it looks like 4 or 5 witnesses. Purported victims. The allegations are minors that were trafficked across state lines for the purposes of illicit, unlawful sexual activity involving those minors. And the defense is happy with that because they'll make it all about the credibility of those 4 victims. Prosecution is happy with that because it limits where the case can go. Court is happy with that because it limits where the case can go, and the court's there to make sure it stays that way. And a lot of people who would have been implicated by this case will probably never be named, will never show up. And the only question is if Ghislaine Maxwell gets convicted, does she stay mute the rest of her life or does she start spilling at some point? That's the part that's unclear. Now, I still think her bail conditions were unconstitutional. That's not a popular position to have, but I believe in the 8th Amendment, regardless of who the defendant is. And she has raised complaints that I think are probably credible that she's being groped and things like that. Wouldn't surprise me at all, given who the jailers are.
Come with a black eye, and apparently she's being awoken or woke. She's been waked up. What do you say? She's being waken up. They're waking her every 15 minutes to make sure she's not dead, lest she meet the Epstein fate. But Robert, I just want to bring in this.
It's like mental torture.
No, dude. I wake up every 2 hours, and unwoken or not, it's still torture. But
I get why people would, morally be completely comfortable with that, given what she's accused of. She's not yet convicted, and that's the problem I have with it from a constitutional perspective.
I'm just going to read this for comic relief. As a middle-aged American, I've had so many I assume pills up my butt. I don't even feel them anymore. Well, I got to tell you, I still feel them, which brings it back to another chat is that I'm too, nice to be American. I still feel them because I didn't even think of it. I didn't appreciate the distinction right away. Appointment versus formal appointment versus confirmed. A very big distinction. Robert, there's a salary difference. I presume it's going to be like $50,000, give or take, on a salary.
Usually there isn't. Usually federal. I don't think so. I think usually federal judges I thought they were all paid the same, but I'm not absolutely certain about that.
Okay, and it's irrelevant. Even if it were, if you go from 2 to 250, you don't go from 200 to 2 million. So it's not
right.
FU money. What it is it's something else.
It's power.
And Robert,
and status. I'm on the Second Circuit Court of Appeal.
Well, and if I'm going to go with the black pill up the butt, they can't, she cannot meet the Epstein fate because twice would be too much, right? I mean, the first time they were stretching.
Instead, the goal is make it look like they did a good job cleaning up their mess without letting the world see what that mess actually looks like.
And we got the squid who says, am I thinking like a conspiracy theorist, which might mean a rational, thoughtful, critical thinker? Or is it just coincidence that the Delta variant coup was announced to distract the public away from important stuff? And now the Omicron is announced ahead of Maxwell trial.
I don't think much will be disclosed at the Maxwell trial. I think that's once that court appointment was shown and once you knew who the prosecutor was. I mean, I thought this from day one, that they would never fully out the scope and scale of, because again, Ghislaine Maxwell's father was a longtime spy master serving a lot of different people. This was a family business. She likely introduced Epstein into it, not the other way around. Honey traps and blackmail and extortion are the currency of trade. Money laundering and arms trading and illicit secrets was likely part of that trade. There's a lot of dead bodies buried, probably why she never thought she could be prosecuted. And essentially the quid pro quo is going to be, we'll give you a viable chance at acquittal in exchange for you keeping your mouth shut about where the rest of this case could go. The court gets nominated to the Second Circuit as long as everything stays in control, and the prosecution gets rewarded for taking down Ghislaine Maxwell while not taking down her key co-conspirators and beneficiaries in the way this case is going to go. So I think it's meant to be very, very controlled in making it doesn't make, and this is very common in political cases. Noriega tried to raise the defense that he was involved in, that he was doing a lot of his work for people here working in certain three-letter agencies in the U.S. government, and it was kept out of the entire trial. And the prosecutor that helped manage that, make sure that happened, was one Robert Mueller. So, you know, that not a surprise, and not a surprise that a Comey's on the case, not a surprise that Southern District of New York. This all fits.
You are what Jordan Peterson would consider harmless. Jim Comey daughter will lead the prosecution. I don't know what the first part means. Robert, field the second part.
She's one of, I don't think she's the lead, but she's one of the two. My understanding is she's one of the two key prosecutors in the case.
Robert,
so, you know, it's
just so nobody
the same Southern District of New York that, while it can't find the other co-conspirators of Jeffrey Epstein and Ghislaine Maxwell, can find excuses to seize the telephones and try to spy on James O'Keefe and pretend that Project Veritas is not a journalist.
Oh, do we do that? I had one more question on Ghislaine Maxwell, but it might be like a 5-minute parentheses. I don't want anyone accusing me of avoiding certain questions for whatever the reasons that they might find to avoid, you know, to accuse me of avoiding those questions. We've talked about it in previous streams. I remember the stream in my mother-in-law's sunroom in the Eastern Townships, where you opened my mind for the first time to Ghislaine Maxwell's history. If you could, before we get into Project Veritas, so no one can say they're not informed. Ghislaine Maxwell, through her father, has a very rich history. Can you, let's see, we're at 136 now. In 3.5 minutes, can you go through Ghislaine Maxwell and her father's history and connections to questionable aspects of American politics?
Sure. So Robert Maxwell managed to successfully flee the commies and the Nazis almost before everyone else, because that's the nature of his capabilities. And so I'll move this over. And so in part of how he did, the rumor was that he became an intelligence source for both the resistance and the communists. Later built up a media empire in the United Kingdom. And the legend was that he had, one of the ways he gathered his wealth was, and power and stature, was his connections to intelligence agencies from Israel to Moscow to London to Langley. And there was a lot of evidence of that. And he was engaged in various allegations of fraud and conspiracy. There are allegations of honeypot stories along the way. And when there was allegations that he stole pension fund money and that he knew a lot of secrets and was going to spill a lot of secrets. And then he disappeared off his yacht, supposedly fell in and drowned right around the time that this could have all happened. That's Ghislaine Maxwell's father. And legend has it that she inherited his traditions and his connections from him and introduced Jeffrey Epstein to that world. A world of money launderers, a world of intelligence operators, a world of conspirators in terms of extortion and bribery and blackmail and honeypot activities, along with Epstein's other agenda, which was eugenics that he shared with Bill Gates. And so that's why Ghislaine Maxwell was considered potentially more consequential than Epstein to understanding how this whole operation worked. And not just ancillary to the whole process. And so that's where I think that there's a logic between the connection, and it goes even further back. I mean, Epstein himself was first hired at the Dalton School by Bill Barr's father, former Attorney General Bill Barr, who Bill Barr's father wrote books talking about underage sexuality while he's a headmaster of an underage school. So, you know, you can draw what inferences you want there. But I mean, it keeps building when you start drawing, when you put pins on the board, the way Mark Grobert and Eric Hunley do on their America's Untold Stories that they're doing currently in the Alec Baldwin context. You do it in the Epstein-Maxwell context. There's a lot of pins on that board that connect a lot of people. And so that's why there would be a lot of people nervous about the Ghislaine Maxwell case and want it to be limited from going too far afield and wandering into Prince Andrew and the royal family, or wandering into Bill Clinton and his many trips to Epstein Island, or wandering into a lot of other high-profile financial players, political players, intelligence operators around the world. There was evidence that Epstein was an informant for Robert Mueller that goes all the way back. Technofog has a good stories on some of that, was the first person to out that. So there's a lot of intel and information that a lot of people would want to see cabined, and watch. The Maxwell trial will be magically cabined at what it presents.
All right, and now I'm just going to bring out Scott Rose, the behavior panel, not the body panel. Scott Rose in the house, and that rhymes, and I just made that up right now. Scott, nice to see you. Thank you very much. The dynamic duo of law. Robert, I'm going to bring back the ordinary view, and I'm going to swap myself back here.
Voila.
Your prediction then? What? I could not.
I don't think she can get a fair jury, impartial jury in New York. And I think she'll be convicted unless there's something about these witnesses that come across as very incredulous. Her focus is going to be that these witnesses made up this story, because my understanding is they've kind of shifted who their focus of the victims is in their second superseding indictment. And the focus now is on people who have made more recent claims, including monetary claims. So she's going to say they made up their claims to get a bunch of money from the Epstein estate. Generally, these kind of accusations, if the witness is even partially believable, lead to convictions. And given the pretrial publicity concerning her, I think it would be very difficult for her to get a jury that thinks anything but convictions. And based on that, I would assume convictions. But maybe I'm wrong about the jury pool, and maybe I'm wrong about, and I don't know how well the witnesses will testify on the stand. That there's the prosecution needs convictions, but convictions in a trial that doesn't endanger politically powerful actors. So that's the tight line they're walking. But I think they've contaminated the jury pool enough to get that. And I think, given the amount of evidence that's accumulated about Maxwell over the years, I think she's probably guilty based on what I've seen. But again, we don't know whether these 4 or 5 key witnesses how credible they'll be on the stand.
And just so everybody's clear, like the indictment against Ghislaine Maxwell is whether or not she facilitated trafficking. Call it that. Perjury. They'll get her on perjury, guaranteed, because they got other people who didn't perjure themselves on perjury. So the only issue is on the bigger ones. And then so they get her convicted without exposing too much, and everyone wins and everyone's happy, and then everyone goes back to watching Sunday Night Football. By the way, Deoden. Yeah, I knew that the harmless was not a compliment. I didn't think it was a compliment. I think it meant ignorant, naive, sissy, and uncourageous. But whatever. I am who I am. I can only be the best of me. Okay, Robert. So trial starts tomorrow. We'll see. Everyone will see what we can do in terms of like real-time updating coverage. No promises, and certainly no one's. I had a joke I can't make. What do we move on to now, Robert?
I'm going to give you how political the Southern District of New York is. They are going after continually Project Veritas, and their new theory is that Project Veritas doesn't meet the definition of press within the First Amendment to the U.S. Constitution.
Now, oh gosh, hold on. We've got Harmeet Dillon might be coming on. If it's not tomorrow, it'll be in the near future. So. And it might be an afternoon, a very quick 30 minutes to 60 minutes type thing, like what I had with, I'm going to forget, John Carpe from the Justice Center for Constitutional Freedoms. If it happens, it might be short notice and it might be quick. But bottom line, we know what happened now. You've seen the videos. The Department of Justice investigates a stolen diary the way you would investigate an individual driving a vehicle into a Christmas parade. Except not. Like, you have the Department of Justice investigating innocuous, nonsensical stuff with such scrutiny compared to the actual serious stuff where you can only think it's politically motivated. Robert, what might be, just so everybody doesn't know, Project Veritas, 2 former journalists and James O'Keefe themselves raided by the FBI, pre-dawn raids allegedly for James O'Keefe. They seize cell phones, a bunch of other stuff, to get confidential information. Harmeet Dillon, who represents James O'Keefe or Project Veritas, I forget which, and I'm not trying to deny the other lawyers their credit. I just forget who represents which. They file for a request to appoint a master Robert, what's the special master?
Yeah.
Who's going to basically say, when you extract the data from these things that you've unlawfully seized, make sure it only relates to that for which you've seized it in the first place. And the Department of Justice refuses or objects, and so that's where it's at there. But what might be, for the people who have not been sufficiently suppository blackpilled for the evening, what might be the political motivation for going after James O'Keefe for a year after the time frame within which they were given this allegedly stolen diary? What might be the political motivation?
Well, it appears to be twofold. It appears first to wanting to punish anyone who was exposing corruption or bad deeds by the sitting president of the United States, as if the FBI in the Southern District of New York are the secret police or private Stasi of the president. And it appears to come across that way as retaliatory, punitive criminal action against anyone for exposing the malfeasance and misconduct of this president by having access to the apparently drug rehab journal of the daughter of the president, who detailed very inappropriate and likely illegal conduct of the president. And at the same time, it's going after a key dissident member of the investigative press that has both exposed a range of misconduct concerning the Biden administration, but also in the current context of exposing issues related to big pharma and related to other aspects like that were scandals of the Biden administration. So it's going after the most significant political media dissident, and it's going after anyone who is exposing personal malfeasance and misconduct by the president, and trying to establish a precedent that if they don't like your journalism, they can call it not journalism, which is they actually made that argument in court.
Okay, so this is the argument. Everyone should appreciate this. There's something called the Privacy Protection Act, Robert, and I don't want to misrepresent it. My understanding basically is that you could seize things if it's the object of theft, unless it was legitimately given to journalistic entities who were themselves not participants in the theft itself. Am I summarizing that relatively accurately?
Yeah, and the other aspect is what I don't think they had any grounds to seize anything from Project Veritas. What crime do they have probable cause Project Veritas committed? They don't. That's problem number one. Problem number two is the requirement of the Fourth Amendment. There's a requirement called particularity. And what it is that you have to define with particularity what you are going to search and what you are going to seize. This stuff, to give you an example, if you go into a office building and you want certain files, you don't get to seize all the file cabinets to find whatever, and then just search through the files and ransack them in the name of searching for the file that you are looking for.
But Robert, to be contrarian, if they have a search warrant that says we get to seize Alex Jones's files, and they show up at your office, and they say, "Well, we've got a filing cabinet in it. It's not in any discernible manner that we can see. We've got to go through all of it and only then pick out what is Alex Jones's files." How do you respond to that?
What's supposed to happen is within the warrant request itself, they're supposed to on site be able to segregate out what is material that's actually relevant to their affidavit of probable cause, of evidence that would be relevant to that probable cause of federal criminal activity. And again, I don't think they even have that here. Just because they think somebody else committed a crime that gave something to Project Veritas is not grounds to execute a search warrant on Project Veritas. Just isn't. And so maybe you could go the grand jury subpoena route for certain limited information, but you're not supposed to go the search warrant aspect unless you believe there's criminal activity in those files of Project Veritas. They clearly didn't have that. That's problem one. Problem two is it has to be they've been abusing this now for a decade. Over 20 years ago, the courts made clear you need to, just because we've shifted from physical files to digital files, doesn't mean the same laws that limited your ability to search physical files don't apply to those digital files. And what's supposed to happen is they're supposed to establish a protocol so they never seize it in the first place, that any of that information goes to a third party, a special master, from the get-go, and then the special master clears what's relevant and what's not. They're never supposed to have access to all the files, but they've been violating it now flagrantly because the Supreme Court has failed to step in.
And just so everybody knows, a special master, it's a very charged term. In Canada, we say that you're the master of your files, you're maître du dossier. Special master is basically just, I don't know how you would legally distinguish it from an amicus, but someone who's appointed by the court.
It's a
to then
neutral third party who's
Okay.
neither who's neither the court nor is not part of the government. A neutral third party the court appoints for the purposes of making sure the Constitution is complied with. That's really what they're there for.
And so, in theory, hypothetically, Robert, maybe I've misunderstood. The government, before they even execute and do whatever they want, before they go in with the pre-dawn raid on James O'Keefe himself, in theory, should have already said, okay, court, we're going to need a special master, pick an independent third party so we don't get accused of any improprieties. They don't do it. They didn't do it. And when it's requested of the defendant, they oppose it.
Yes, correct. Exactly. And I mean, my view, they had no grounds to execute a search warrant here, period. There's no probable cause they have Project Veritas committed any crime at all. That's big problem number one. Problem number two is it appears to be circumventing the grand jury process. When you're issued a grand jury subpoena, you're allowed to petition to quash that grand jury subpoena before the court. When you're not supposed to, as a government, say, well, screw you, now we'll go do a search warrant. That's basically undermining the ability of your right to petition to quash a grand jury subpoena. So it appears that's also what they did here, which is an abusive judicial process. And then third, they're supposed to have a strict protocol in the search warrant itself to prevent them from even seizing or searching materials beyond the permissive scope of the warrant. And clearly they didn't. They just grabbed whole phones, grabbed whole computers. They were never entitled to that.
And this is the best part of their argument, which I covered in the video a few days ago, where they said, okay, fine, so we've seized solicitor-client privilege. It's not journalistic materials, so we don't have to worry about anything in the law because we haven't seized journalistic materials, but only solicitor-client stuff, and that's not covered by the law. To which, Robert, for anyone who doesn't speak legalese, break it down for them. After you've
they're definitely not entitled to attorney-client privilege materials. And I don't understand how clearly they did seize it, and because clearly they leaked it to the New York Times, and the New York Times printed it. So I mean, it's just overt criminal behavior by the Southern District of New York that's only occurring because the courts in the Southern District of New York are a joke when it comes to disciplining the federal prosecutor there. I mean, they're clearly they run amok. They run amok routinely and repeatedly. A court will find them running amok, scold them with big words, and then nothing happens. And this is just egregious. And it's only because Project Veritas's politics are outside of the popular politics within the Southern District of New York that this could even happen. Does anybody think they would even try this with the New York Times? They wouldn't blink twice. Instead, they're complicit and colluding with the New York Times to violate the constitutional rights of Project Veritas in order to establish a precedent that they can label any dissident press no longer press. According to the government, you're only press if the government approves of you. If you're not, then you're no longer press, when it's just the opposite that the First Amendment is all about. It's about protecting the press that's critical of the government, not the government's propagandists like the New York Times.
The argument from the government was that you're not journalists if you publish things that were surreptitiously obtained or published without consent. And I was like, that's
under their definition, Upton Sinclair was never a journalist. Under their definition, every muckraker in American history was not a journalist. Under their definition, Bob Woodward, when he was doing the Watergate story, was not a journalist. That's how absurd, inane, and insane their definition of it is. What they're saying is only state-sanctioned propaganda constitutes free press, when it's actually just the opposite that our founders intended in establishing the right of the free press against the government.
You're preaching to the choir, Robert, but I'm going to bring this one up here. It says, Happy Hanukkah. In the sight of heaven, there is no difference between saving by many or by few. It is not on the size of the army that victory in battle depends, but strength comes from heaven. Well, first of all, it's beautiful. And the arrows and shoots in the avatar. So we'll see what happens with this. Thus far, there's been the back and forth from what the government said. It was the order of things in the ruling from November 12th. It's defendants file, government responds. If there's a response from the defendant, they will. They did. We'll see where it goes. We'll see if we can get Harmeet Dillon on. If it's not for a sidebar, it'll be for an afternoon coffee. But it's nuts. There's no other word to describe what's going on with Project Veritas other than nuts. It's non-violent nuts. It's litigious nuts. It's lawfare nuts. But it's politicized, corrupt nuts. And those are the worst types to eat.
Well, and to Glenn Greenwald's credit, He's come to the defense of Project Veritas because once they started down this path with Julian Assange of deciding that the state can decide who is and isn't free press, who isn't press in the first place, they were going to keep doing it. And some of us said it was very dangerous, the precedent they were trying to establish. They did it with Julian Assange. They did it with Alex Jones. Now they're doing it with Project Veritas. And their goal is to say anybody who disagrees with us is not press. If you're not part of the institutional gatekeeper-approved narrative, you're not press. And that's precisely who is press under the First Amendment to the U.S. Constitution. When they wrote the First Amendment, they had Project Veritas in mind as free press to be protected, not the New York Times. The New York Times doesn't need the Constitution's protection. They got plenty of billionaire protection to begin with. So and institutional protection as well. But it's just part of the process, and it's good to see Project Veritas continue to fight back, and hopefully the court recognizes their rights in the process and reaffirms those rights against this real threat to free press, which is what the Project Veritas cases really are in the end.
All right, and I guess I don't know what we're going to have to speak about it until the trial starts. But Kim Potter, her trial is coming up. This is the cop who shot. Who did she shoot, Robert? I again.
So this happened, I believe, during the Chauvin trial. They pulled her and her partner pulled over an individual for violating various traffic rules. In running his name, they found out he had an existing warrant on, I believe, weapons charges. So when they went to arrest him, they got him out of the car, and all of a sudden the driver of the car broke off from the police officer, got in the car, and was trying to race off with the car with her, Kim Potter's partner, in danger from that happening. So she believed she pulled out her taser to tase him, said taser, 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 didn't stop that guy from wanting to pull away. Instead, she pulled her gun and shot him. She's now being charged with first and second degree manslaughter. And the issue, it really, in my view, comes down to, could she have pulled her gun? Because if she could have pulled her gun in that situation, it doesn't matter that she meant to pull her taser. Then it's a lawful exercise of force or self-defense, however you characterize it. If she wasn't entitled to pull her gun, then arguably she wasn't even entitled to pull her taser. So it doesn't matter that she pulled the wrong one. So in the end, it comes down to, was she entitled to pull her gun at the time, even though she didn't mean to pull it? And I think that's going to be the question. And I just don't think it's possible to get an impartial jury on use of force in the Twin Cities. I don't think there's anything she can do to get a fair trial, in my view. So I think she'll be convicted, even though I don't think the evidence supports that. I think she could exercise force in that instance because her partner was attached to the car and could have been killed by that guy driving off with the officer in the place he was at. And she could defend the life of the officer against this fleeing felon who is threatening and endangering the life of her partner. So even though she didn't intend to pull the gun, I believe she lawfully was in the right to do so, or at least I haven't seen evidence beyond a reasonable doubt in the to date. Again, the trial hasn't started yet to say so. Now she's on tape saying, "Oh my God, I didn't mean to shoot him. I'm going to prison." So that obviously is damaging for her in front of the jury potentially. But again, if she had the right to pull the gun, the fact that she pulled the taser is kind of exculpatory. She was just trying to tase him, not shoot him, even though she was in the lawful right to do so, if that was the case. I just don't think she can get a fair jury in the Twin Cities. I don't think any cop can anytime soon.
That'll bring me to the second question. The first one was I two things. His name is Duwante Wright, and I do not forget names to be disrespectful. And no, but I also brought up a comment about the name, which I did not bring up to be disrespectful. So don't read into things. I bring up a lot of chats. Duwante Wright was the person that she shot. This is the question. In law, hypothetically, if she would have been entitled to use lethal force, but she opted to use for non-lethal force, although tasers are, potentially lethal, is it a subsidiary defense to the charges that are currently being brought against her that I didn't do what I'm accused of doing, but even if I had done what I'm accused of doing, I would have been lawfully entitled to do it? Is that a defense that's on the table?
I think it's her primary defense. Okay. Because now there are people who have pulled guns instead of tasers and been acquitted of the highest charges. So there was a famous case out of Oakland that my recollection was a split verdict. Got convicted on something lesser, but not the top count. So they believed him that he thought he was pulling his taser. But, when a person's driving, putting a taser on him, to me, is potentially lethal force. So that's where I think there's a lot of focus on the fact that she one of the thought she'd pulled a taser. I don't think it matters really in the end because he could have died from the taser, I think, as well under the circumstances. I think, to be honest, I think a gun was actually safer in terms of her partner than her partner's safety than a taser would have been. A taser he might have led to the car still going in such a direction that her partner suffered severe harm. So I think that given when I watched the video, I thought it was a justifiable use of force, was my instinctual read. I just don't think a jury is ever going to acquit in the Twin Cities of anybody accused of a interracial excessive use of force, even though her partner, I believe, was African-American, who was attacked by this defendant in the process of arrest.
No, and a second ago when I said less lethal, if she hypothetically she pulls the taser and then hypothetically it's the right taser, it makes connections, but the guy's driving a car. Tasers are on cables. I don't know how long they are. Once you get past the even if you're involuntarily body movement to that point, once you get past that certain length, they unclip from the skin, so you're no longer being tased. So the taser itself from a fleeing, allegedly violent suspect who might have your partner in the door, once the taser gets unplugged or whatever, unless I'm wrong on this, people, and correct me if I am, it's a much greater risk, not to the driver, but to your potential partner who's at risk. So the lethal force might have been the most logical force to eliminate the risk to your partner, who's a police officer. If that's not right, someone correct me, but I think that is, because I at one point didn't fully appreciate tasers are on cables. They have to make connection to the skin, and if they don't make proper connection, they don't have an effect, and if they do and get pulled out, effect is over. And if the dude's driving a car away, well, that's a very quick period within which to lose connection. So that'll be the subsidiary argument, which was I could have used lethal force and I should have, so I can't be found guilty of involuntary manslaughter. I mean, what are the charges against her again?
Yeah, I mean, it's first and second degree manslaughter, and one is culpable negligence, though culpable negligence really equals recklessness, and then it's a higher level of recklessness for the other. And my view is, either way, it comes down to, was this excessive force or not? Because if it was not excessive, if it was a lawful use of force, then it's lawful, period. It's by definition not culpable negligence or gross recklessness. And so I think for that reason, just based on the video, and I don't have all the evidence, but just based on the video, I would say there isn't evidence beyond a reasonable doubt to convict her. But I don't think any Twin Cities jury will be fair for a while, particularly in any interracial shooting by police. But definitely in the current context of the George Floyd era of Minneapolis and Twin Cities.
And this is like, Robert, we've talked about this. It's the incidental side effects of this is that she tried to go with the less lethal force, for right or for wrong. I don't know if this is true, but both darts need to make contact, 50-50 drink. If this is going to be the effect now of the attempt to make lesser force, well, then in the future, fewer cops are going to try to make lesser force. They'll go straight for the gun in the first place. If they successfully prosecute and convict Kim Potter for having gone with the lesser of the lethal force for what would have otherwise been justifiable lethal force, a dude trying to make off in a minivan with a potential partner caught in the crosshairs or in the kerfuffle. So, all right. Well, again, I think I know what I think of this case. I will withhold
now.
Until
that trial will be video broadcast, is my understanding.
And Andrew Branca is going to be following it. So I don't know if Rakeda will be. It starts this week. Is it on Wednesday or Thursday?
I think it starts. I think jury selection starts Tuesday. Maybe okay. The trial starts Tuesday. Something starts Tuesday.
All right. Well, we'll be on it
along with Ghislaine Maxwell.
Ghislaine Maxwell might be by phone, if the phone lines don't crash. Kim Potter is going to be broadcast, so we're gonna see that. And is Viva guilty of stealing Geraldo Rivera's voice? Well, I'll tell you what, I'm not guilty of stealing of Geraldo Rivera. I can't even finish that sentence. I have no idea. I have no opinion of Geraldo Rivera. Robert, hold on. We got Dapper Dave says she's entitled to self-defense, experts to testify on her behalf. The other officer is probably going to say he feared for his own life when he testifies, which should be exculpatory for an officer who thinks she's pulling her.
And the other thing that's true about this case, that kid's probably alive, except for that officer not being very physical with his effort to arrest him. I think because of the political dynamics in the Twin Cities, because this happened during the middle of the jury verdict, during the deliberations in the Chauvin case, I think is why that officer was not being very forceful in how he was physically arresting him. And that's what allowed that the suspect to escape police officer's custody and get in a car. I think that happened because he was like, I better be careful, in the current setting, better not be uber aggressive, better not be too physical, better not do anything that looks bad. And that's what happened, unfortunately. So we'll see.
All right. And we did have on the menu the Canadian stuff, but we don't need to go over the Canadian stuff. Just watch my Viva on the street from last night. And by the way, people, I do apologize. I'm not getting my face in the shots anymore, or at least consistently, because it's getting colder and colder. And as you're colder, my phone goes down and I don't get my whole face. But whatever. I talked about the Canadian stuff last night. But Robert, what do we have? The big stuff that's left on our menu that we didn't get to.
The vaccine mandate case
Yes,
updates.
please.
Currently, not a lot of district courts denied relief this past week on grounds of either following Jacobson or rational basis, or they said no irreparable injury, you can get economic recovery. They had different excuses, the different courts. All it's doing is feeding the cases up through the appellate food chain and going up ultimately, in my view, likely to the U.S. Supreme Court. On top of that, the OSHA mandate is now before the Sixth Circuit. It won the lottery. The way that works is when you have a bunch of when you go directly to an appeals court, which is rare. It's only OSHA type rule issues that go directly to the appeals courts. Then they do a lottery to decide which appeals court handles it. The Sixth Circuit got assigned. The Fifth Circuit stays in force until the Sixth Circuit rules. It'll be ruling within a week or two. There's the Ninth Circuit did issue a temporary stay for prison guards. And it's interesting. California found a way for prison guards, maybe related to the prison guards making a big donation to Newsom during his recall campaign, but managed to find a way to not have a vaccine mandate for them. The argument was prisoners were suing on Eighth Amendment grounds that it was cruel and inhumane treatment to not require all the prison guards and prison staff to be vaccinated on the grounds that it imposed an undue risk of COVID to them. Interestingly, in this context, the government has said it doesn't pose such a risk, even in the prison context, which is much more likely to transmit a disease like COVID than most employment settings, most hospital settings. And yet they found alternative ways to make sure that people that doesn't spread lethal COVID without a vaccine mandate. And the Ninth Circuit agrees for the time being until the full appeal is heard. There's also COVID vaccine mandate challenges of different kinds, or vaccine passport challenges of different kinds, pending everywhere from Kenya to India. So we're going to see worldwide global challenges to this. And as the new South African variant came up, Biden suddenly wants to stop African travel, which when Trump did it, Biden called it racist. Now when Biden does it, I guess somehow it's magically not racist.
But same thing in Canada, by the way. Back in the day, it was racist to restrict travel from China. Now everyone's begging Trudeau to ban travel from South Africa. It's disgusting. Intellectual dishonesty is always disgusting. But yes, I'm sorry, Robert, I cut you off.
Yeah. So all these cases are still percolating up. I want to bring a challenge to the FDA's redefinition of the word vaccine under the APA as part of the children's health defense suits we're bringing in Texas, because to me, the FDA, it does not. Can the FDA just redefine a drug as a vaccine by redefining what the word vaccine even means to meet that definition, knowing it's going to trigger a bunch of public health consequences of mandatory vaccines around the country? Or is there some limits? Because here they didn't go through the notice and comment process. They didn't go through the citizen petition process. They didn't meaningfully address criticisms and questions and comments about that precise issue. They just chose to unilaterally redefine the word vaccine to mean something it has never meant in the history of the word vaccine. And, are we really living in sort of Alice in Wonderland, where a word is what I say it is, as Humpty Dumpty says? Or are there some restrictions? We're also going to challenge the misuse and abuse of emergency power itself. I don't think they're using that statute, the emergency use authorization statute, to say they can now license drugs effectively. They're not licensing them, they're only approving them, but they're treating them like licensed drugs by their marketing. They're marketing to children that this drug, and marketing to the world, this drug is safe and effective when it hasn't been biologically licensed for the purposes of broad availability or accessibility. What's available is not a broadly licensed drug. Is that okay or not okay? Because historically it hasn't been okay. They're saying, well, you can't review it and the legislature can't question it and we get to do it and the citizens can't challenge it and we're not governed by the APA because we're calling it all under the emergency powers, even though there is no emergency for children currently. Or shouldn't be. I mean, there is no emergency that meets it from a factual standpoint. So we're challenging the underlying misuse and abuse of these laws as well, along with all the vaccine mandate litigations pending against Tyson Foods. Tyson Foods says they're a federal officer, so we're challenging it now under the Constitution and the Religious Freedom and Restoration Act. A federal court says that it looks like the military is going to discriminate against people that are asserting religious objections. So it demanded the military to report on a constant basis whether or not how many exemptions religiously it's granting. And the court really kind of put the military on notice that it better start meaningfully granting those exemptions, or the court will believe that it's likely discriminating on religious grounds in violation of the Religious Freedom and Restoration Act. So that's basically where it stands. It's sort of at a standstill, different courts ruling different ways based on unique facts of individualized cases. Southwest Airlines, they said you had to go back to arbitration rather than go to court. So there's a lot of things that are distinct to each case. Ultimately, the U.S. Supreme Court's got to step in and provide clarity. Does the First Amendment matter? Does the rights against religious discrimination matter? I think they will ultimately rule that way, but there's disagreement within the courts as to what's going to happen.
Robert, someone had a chat and I lost it. Let me see if I can bring it back up. Oh, it wasn't a super chat. It was a chat. Vaccinate your dogs. Google it, by the way, for those of you who think this might be a joke. There was discussion about vaccinating companion pets because there have been cases of coronavirus being transmitted through pets. So you make jokes. Did someone just say I thought you said I'm far left. Spreading fear via left. I thought someone said Viva is left, which I'm perfectly in the center. The jokes aside about the pets, companion animals are next on the line, and just clip this bit here, but it's not even my own insight. It's people have been talking about it. Robert, Steve Bannon, what's been going on with Bannon?
So Bannon is objecting to what Bannon wants is to use the case to expose the incredulous nature of the January 6th committee.
If I may just stop you there, just everyone, Bannon has been subpoenaed. He's been charged with a crime of contempt of Congress. So contempt of Congress for violating a congressional subpoena to bring with him documents that he alleged, rightly or wrongly, that's a separate adjudication, were subject to privilege.
Executive privilege.
Executive privilege. They went ahead and said, we're going to try to hold you in contempt of Congress. I covered it last week, and we talked about it last week. But so, yeah, that's the context. What's the update?
And so the update is that the government wants all the discovery in the case to be limited, number one. And number two, they don't want any of it to become part of the public record. They want it all to be under a protective order. So Bannon is objecting to that. He wants a much broader range of discovery, and he wants it all to be part of the public record. So that's the current fight. So we'll see how that turns up. There was the NFL settled with the NFL moved from the St. Louis Rams moved from St. Louis to L.A. The city of St. Louis sued. Sports Illustrated and some of the smart set of lawyers claimed that they had no chance. The city of St. Louis had no chance to win. Well, this week, the NFL is writing a check close to $1 billion for the city of to avoid disclosure of their financial records.
Stop it right there. The city of St. Louis sued, and the basis of their suit was that they prematurely or unlawfully moved the city from which they operated, which cost the city. I mean, one can only imagine how much money hosting NFL games brings in. So they say, we're up and leaving. Where do they go to, Robert?
LA.
Okay. And St. Louis then says you had no lawful basis to go away because you had a contractual obligation. Do we know what the contractual obligations were to stay within the city of St. Louis? Or
their theory was that they were a third-party beneficiary to the NFL's agreement amongst itself. Really? So it was a unique theory. And this is why Sports Illustrated, other people were critical and like, this isn't going to fly. They understood the politics in St. Louis favored them, of course. And so the court was going to allow the case to get to trial, and the appeals courts were refusing to intervene to bail out the NFL, and was going to require the NFL to disclose Jerry Jones and other people's financial records about their teams that they've kept buried as far deep as they can. And they were on the eve of both that discovery orders being enforced and going to trial in January. And all of a sudden, they decided to write a big fat check. And they wrote a check much bigger than what they could probably prove their real damages are, close to $1 billion. I think it's over 700 million. They're writing that their NFL is writing just to avoid public disclosure and a public trial over what happened. But it was credit to the city of St. Louis for creative legal theories, arguing they were the third-party beneficiary to an internal agreement amongst NFL owners.
So that's nuts, because I didn't realize they were not a party to the contract. And then the damage is being paid out. Who are the defendants that contribute to that? And do we know in what proportion, or it doesn't matter?
We don't know. It says the St. Louis Rams owner plus the NFL. We don't know how they're coming up. Who's coming up with how much cash? Now the NFL, that owner is a very wealthy real estate guy. So,
sorry. Say what you just said again.
The Rams owner is a very wealthy real estate guy, so he could write the whole check himself if he wanted to.
And they are paying it to the city, or I'm saying city. They're paying
the
it to
city
St.
and
Louis.
The county of St. Louis, because both were parties. Now, that the NFL is out of full hot water because John Gruden has brought suit for their basic efforts to run him out of the league. In reality, because they don't like his politics, but on paper because of 10-year-old emails that they dug up in a questionable manner. So that suit's going to be ongoing. A interesting case that recently developed. There's a Torture Victims Act that allows people to sue in the United States courts for being tortured anywhere in the world by state actors. And a federal court found that the Colombian militias were actually state actors of the Colombian government, which has been long alleged, but not yet proven. And so they can be held liable under the torture laws that allow victim recovery. So that was so you'll likely see more of those kind of cases come up in U.S. jurisdictions, where a lot of times these torture groups aren't just backed by the government in their local country, backed by one closer to home. So we'll see where some discovery goes in some of those cases. There was some news in the McDonald's ice cream machine hacker case.
This one's too complicated for me. I know I've seen the original video about why upwards of 10% of the McDonald's ice cream machines are not working. They have a contract with some provider, and they want all the franchisees to use this service provider. And when the franchisees found there was an alternative solution to the problems, McDonald's comes down with a heavy hand and says, if you use that, it's going to invalidate the warranty, and it's going to violate the terms of our franchisor agreement. Oversimplified, but Robert, simplified for the rest of us.
Yeah, that's it. And then they went after somebody who helped present evidence to prove this. They went after that person, accused him of hacking, a whole bunch of other things. Those cases continue to develop in interesting ways, and actually more harmful to McDonald's, because now internal emails are coming out that raise question about what McDonald's was actually up to in terms of its public justification versus its internal justification. Cardi B is having to produce the outcome of her STD test. Because she sued for libel related to whether or not she had certain, and she was happy to publicize it because she wants to prove she does not have certain STDs to the world. So that is what. But it was one of those headlines I had to look like 3 times. I was like, what? But that's apparently what that's about.
This is where these are stories that I will read. I will laugh at behind closed doors, but I don't make them public until they make them public, and then they make them public. Yeah, someone says, I'm thinking of Candace Owens and the Mademoiselle, I forget her name now. When you sue for these things, it's going to be public, and then you're going to have to actually make evidence of that which you're suing for or being sued for. And I don't care about Cardi B's STDs. Full stop. What I do care about is whether or not she's going to be found guilty in her upcoming trial next week, Robert. What's your take? I don't know enough about that. She orchestrated or allegedly organized the beating of a bartender. Robert, do you want to fill me in so I don't misrepresent what's going on and what's happening next week?
I don't know any more than you do on that one. I just know she manages to get herself in the legal news quite often these days, and with interesting headlines.
Well, and by the way, so we don't cover everything this week. We're going to stop on Cardi B. Nate the lawyer, and we might be covering Cardi B. Upcoming week, Kim Potter is going to be on Andrew Branca, Law of Self-Defense, and others. Nick Rekieta, from what I understand, is going to have photo guy Chad, the photographer, for a live stream some point this week. Oh man, and how much more news can you have in any given day without not sleeping and still being compelled to produce, coverage?
One piece of fake news out there was that there was a parody site that put up a headline that said Kyle Rittenhouse sues The View for $60 million. That was a parody site. That was not a true story. There's been no defamation suit brought. But he may bring one, but that was a fake news headline for everybody out there.
His name is De Bruyne, and his name is Photo Chad. Thank you, Judo Black. So, with that said, by the way, I do think Joe Neerman is going live now. I don't think I'm going to be able to step in there to adjudicate, nor would I have any expertise to do so. It's going to be the Chad versus Carruthers, Chad versus Kyle shooting. Joe Neerman. Anyways, everyone knows where the law stuffs are on the interwebs. Robert, do we know who we have for Wednesday for Sidebar?
I don't know if I'll be available on Wednesday, so it was kind of awaiting my own scheduling. For Wednesday. So maybe George Gammon, but there's some other people that have been put on hold. But I don't know whether I won't know until Monday if I'm available on Wednesday.
Okay. So. And hell or high water, people, we're going to have a Sidebar Wednesday. If we can get Harmeet Dillon before then or after then, there's been some discussion with the quartering. There's too much to cover. There's too much to actually schedule. So where can we find us, Robert, if anyone wants to find us on the social medias?
Oh, yeah. So at vivabarneslaw.locals.com.
Hold on one second. Let me take Photo Chat down, for goodness sake. Let me do this again. Robert, where can people find us?
At vivabarneslaw.locals.com. There's a live chat going on there. I'll be there briefly after the show for a little while. And that's we're going to continue to put up a lot of content on the any vaccine mandate cases and other aspects for the exemplar letter that people have asked about. That's pinned to the top of the board. And any information that develops on the vaccine mandate context, that's where the information will be provided.
All right, people. And that's going to be it. Now, so you can find us on vivabarneslaw.locals.com. We've got all of our streams are on podcast. It is Viva and Barnes Law for the People, and it's on iTunes and all the other podcast platforms. Robert, we hit 500,000 downloads on podcast, which is amazing. Merch, who cares about merch? You can find the links elsewhere. Most important of anything, social media. We're going to be covering the stuff that matters in a way that is honest and insightful and spin-free. And I don't want to say spin-free. That sounds like Fox News. Honest and thorough. So Wednesday, something's going to happen. During the week, something's going to happen. Everything else, people, thank you for the super chat. Thank you for the support. Thank you for the super chats. Thank you for sharing and everything. But Robert, end the week. Bring us into the new week. Give us something to look forward to before we say goodnight.
Hopefully we'll have some good news on the vaccine mandate context, either from the Sixth Circuit on the OSHA case or from the Ninth Circuit on the prison guard case. I'm hoping that there's positive movement on the vaccine mandate cases in the courts this week and next week.
All right.
I mean, there was good news in the big auto unions folded, or the big auto companies folded, and are not going to require vaccine mandates of auto workers. So that was a great achievement this past week, and that's only because people are fighting back in the court of public opinion that these mandates are being stopped at all. And so it's good to see that occurring. So there's still fights yet to be had, but there's been more fights won than ever in the history of vaccine mandates in America.
And with all that said, people, despite everything that the American and Canadian and Australian and the world has done over the last 2 years, you have people coming in now and saying the Omicron variation, start from scratch. You're all getting locked in over Christmas. So we may not protest as hard as other people might like. We might protest more than some people do. Know what the law is, know the stuff, and then know what you can do without just exposing yourself to unnecessary risk and punishment. So with that said, Robert, stick around. We'll say our proper goodbyes. This will also be on podcast tomorrow. And that's it. Enjoy the rest of the weekend, people. Peace out. Booyah.